good evening and happy Wednesday to all of you. Glad to see you guys here. Hope you guys are having a good week and hope you are getting stuff done in that wonderful, wonderful week that feels more and more like spring the longer we go. Hope you guys are doing well. Let's see if we can't get rolling on some stuff because today we had finally, we got closing arguments in the Murdaugh trial on day 27, closing arguments from the prosecution. First off in the morning, the jury got to go and see the property. They got escorted out there with the judge wearing street clothes, and one pool reporter was lucky enough to be escorted along with them. And then when we got back, the state had their opportunity to put all of the evidence that we've heard over the past 26 days of trial and consolidate it into what we are hoping is a concise statement of the evidence in favor of the prosecution's request for a conviction. So, initial impressions. There were a lot of questions that Creighton Waters asked today. Generally speaking, those aren't really a good sign. You would like the prosecution to come in with a very concise and a very streamlined narrative. And you don't really want to see them asking questions because it allows the jury to make the decision or make the judgment call in one direction or the other. You don't know which way they're going to go. And I had opinions on the closing, but I think let's go ahead and reserve some of those for where we get to some of those statements. The closing arguments for Creighton Waters can be basically summarized in parts 1 and 2. Part 1 was pre-lunch, and that dealt with primarily financial crimes. And then part 2 was after lunch, where we finally got to the timeline. You can almost look at these two as two separate closing arguments. That was my initial impression. Watching this in real time, it felt like the entire first part of this closing argument was aimed at a financial crimes prosecution rather than the actual murder. And it really confused me that was being asked or that was being presented in this way, because a lot of it, when the end of that closing, I had even more doubts that the financial crimes were the motive to any particular killing. But you know what? We'll go through it because I do want to give this. I want to give it every. What's the best way to say this? I want to give this the weight that I imagine a jury would, rather than me as an attorney. And then I'm going to give my inflection or give my input when we get to points where I think as an attorney, I have tactical opinions on things that were said by Mr. Waters. But without further ado, let's see if we can't get some of this rolling. I'm going to bump Creighton's speed up to about 1.5. He did pretty good today at not speed talking. We'll go there. What I will say at the outset, as we're discussing this. So first of all, my name is Rob. If you guys are first-time viewers of the channel, very glad to have you here. If you like the content, please subscribe. If you are here, I see that there's a bunch of you here already. If you wouldn't mind liking the video, it does help drive people to the stream so that we can have this discussion. I do also want to make it very clear that we're having a discussion. This is a discussion, and this is where we can air different opinions in one direction or the other. No opinion is wrong. And I want to avoid people name calling, anything like that. Right now, we're just analyzing the state's closing argument and trying to kind of surmise where it is the jury might be and where a jury could view the evidence most favorable to the state in favor of guilt, and where there are some things that the defense can analyze here. So, yeah, catching some of these really early super chats just to get them out of the way so they're still in context. Guy's neighborhood, I'm putting myself forward as a phone-eating expert in this case. Oh, that was interesting testimony yesterday from the state's rebuttal case, because we had an expert witness that was an expert in phone forensics, who basically testified that over the weekend they had some fun throwing their phone around the office, didn't record anything, didn't think it was necessary to record anything that they were going to testify about, and they just tossed the phone around. Well, I did that 2 weeks ago. I'm pretty sure that jurors probably did that 2 weeks ago too. I don't know why that was even offered. It was at the end of the cross. I was more confused than I was when I went into it. I thought the state's case was stronger before their rebuttal case went forward. And I did think that Kinsley tried to wrap it up in the end, and he did pretty well. But it was a wild day yesterday. I've back to the super chat. Sky's neighborhood. I've yeeted my phone an estimated 400 times in a variety of controlled conditions. Yeah, I learned something, and that I'm pretty accurate at throwing my phone like against a couch or across the room. My phone was not damaged in the process. But yeah, I probably could have gotten on the stand and been qualified as an expert in phone yeeting. That was kind of funny though. Jasha Ten Hog, thank you. Good evening, Rob. Thank you for spending your free time with us. I love that you do this for us. Thank you very much. That's very much appreciated. Magical Mary, jurors' mind shouldn't be made up with closing as it's not actual evidence. Yes or no? Yes and no. The closing argument is the opportunity for the state to consolidate all of the evidence that you've heard over several weeks of trial. And there's so much evidence that the state has the opportunity, and the defense does too, to kind of summarize that. And they summarize the evidence that's in the most favorable position to them. So this isn't evidence, but this is a recitation of the evidence and how the jury should view it. This is very different from opening statements. Opening statements is a statement. It's a statement of what they believe the evidence is going to show. You're not allowed to argue during opening statements. So you're not allowed to suggest that the evidence should be viewed in one way or the other. You're not allowed to suggest that you should form an opinion as to the truth or veracity of certain statements being offered. And you're not allowed to just imply that certain things mean anything other than what is actually just being presented in testimony. So the argument is the argument phase. That's when the prosecution has the opportunity to argue the evidence and say, this evidence shows this, and this is how you should infer A, B, or C from what you heard over the past few weeks. That's that. AL, thank you very much for the super chat. Very much appreciated. Sagebrush Farmer, thank you very much. Reports about a note going to the judge about a juror last night. Also reports that something happened on the field trip this morning. Thoughts? I saw a bunch of sidebars, and then the attorneys went back in chambers to review some stuff, and I have questions about what they're reviewing. I'm wondering if they're going to put it on the record. We will see. We will see. I think there's been a couple of sidebars the past 2 days that have made me very, very curious. So we're going to have to see what's happening there. And then as far as what happened this morning, I'm not sure on that. I'll check the reporting this evening when I get a chance. JR, thank you. I vote we just go Burrow. Doug's caller up and Bubba can just tell us what happened, because I need answers. And right now I only trust Bubba. If there was only a dog whisperer, and if only that dog whisperer could actually give evidence at trial, we might have some answers that I don't know that we're ever going to get. That's the problem that I'm seeing with this case, is the investigation basically left us with trying to reach conclusions on inferences. And you're allowed to do that. Jury's allowed to do that. Circumstantial case doesn't mean it's not a case. I just don't know that this was argued as strongly as it needed to be in this particular instance. Carrie, when's the next TOTC? After Murdaugh. Murdaugh is essentially so all-consuming. TOTC, for those of you guys who are new, is Trials of the Century. It is a joint effort between Mr. Ian Runkle of the Bailey, Scott Cardinal, and myself, where we analyze old historic trials and discuss them and try to. I like history, so I like bringing people back to essentially use history in the present sense. But Trials of the Century is a little bit on hold while we're doing the Murdaugh stuff, because there's too much. And today, in particular, with closing arguments, there wasn't a way I was going to be able to get away with not covering some of these closing arguments as they're happening. So that's what that is. And then I'm seeing there, James McCourt said the email yesterday was about juror's spouse posting a social media video saying their spouse was on the jury. That is concerning. I don't know that would disqualify that particular juror, and I don't know whether it's true or not. I think right now it's kind of just, we'll see what the judge does tomorrow. We will, because tomorrow will be day 28 and we'll get the defense's closing there. CMS, thank you very much for the very generous super chat. Haven't seen you nearly enough. Thank you for all you do, Rob. Yeah, I was at the Gundys in Texas, where I was helping, well, rather just supporting my friend Ian, who was up for 2 awards and won one of those awards for Breakout Content Creator of the Year, which is pretty amazing to go and spend that time. Got to see a rhinoceros in person, got to go and do a thermal imaging safari, met some really cool people, had a really fun time. And I have a new addition to my background that you guys can probably see right above me. It's a little tie that seems that it made its way from Texas back to my house because someone slipped that tie into my bag before I left. So thank you, CMS. Glad you're here. And I'm glad that we get to go and talk about all of this stuff because there's a lot that's pretty important. Let's do this. Let's get right into the testimony. Make sure I've got the right video pulled up because not Long Crime Court TV, which has the better audio, split their stream today into 2 separate streams. So make sure we're on the right one. So let's get into it. Let's see. Make sure that you guys can hear this. We'll play it. Let me know if you can't hear it, and we'll go from there.
It's been a long trial, hasn't it? On June 7th, 2021, at the Moselle property in Colleton County, Maggie Murdaugh and Paul Murdaugh were brutally and maliciously murdered at the kennels by Alex Murdaugh. Paul, as you know, suffered 2 shotgun blasts. Maggie suffered 5 blackout rifle wounds. And after an exhaustive investigation, there was only one person who had the motive, who had the means, who had the opportunity to commit these crimes, and also whose guilty conduct after these crimes betrays him. There's a
pausing here because this is the first instance that you're actually seeing guilty conduct being argued. Guilty conduct, essentially actions that were taken after the crime itself that suggest that the person had a guilty conscience and therefore should be viewed as having done this crime themselves. So it was interesting to see Creighton throw this out right at the beginning. I appreciated that his initial opening to his closing argument was, this is what happened on that day. And this is why you should infer guilt from that. So let's go through.
The defendant is the one person who was living a lie. The defendant is the person on which a storm was descending. And the defendant is a person where his own storm would actually mean consequences for Maggie and Paul and consequences for those who trusted him. And that person is the defendant, Richard Alexander Murdaugh. I know this has been a long trial because it's a complicated case. And I'm not going to talk forever, I promise. But I am going to try to distill this down for you. And the first thing I want to do is set the stage. And to set the stage, we have to understand a little bit about Alex Murdaugh and who he was and who he is. He was a person of singular prominence and respect.
Did you guys see the little bump? We'll do it again.
And who he is.
Boom.
He was a person of singular prominence and respect in this community. But he's also a person who's been able to avoid accountability for all of his life. While he was outwardly giving the illusion of wealth and a very lucrative law practice, some bad land deals and that sort of thing, exacerbated by the economic recession, led to some financial problems. And then he had some big cases in the early 2011, 2012. And all his partners, and you've heard testimony to this, thought that had taken care of things. You've heard cases like the Thomas case and the Pinckney case and the Plower case and the Badger case. But the evidence that you've heard,
Kathleen, we're up at 1.25 just so that we can get some of this covered.
The velocity of money, that the millions of dollars in legal fees that he was receiving was not enough. And so he started to steal. And how did he steal? He stole by billing personal expenses to the firm. He stole by stealing from his own family. You heard the testimony about the check he stole from his brother Randy. But then the main ways were 2 schemes that he developed. And the first one was to get checks made out from the client trust account to Palmetto State Bank, to fast talk the staff and fast talk the clients with those disbursements, and then take it to Palmetto State Bank, where his buddy Russell Lafitte would convert those and use those to pay personal expenses. And each time, until the end, it worked because the client was also getting a big check. And they were walking out of there thinking that everything had been fine when it was not. But then in 2015, he opened up the fake Forge account. And then all he had to do was get disbursements paid out to the Forge account. And once he did that, he would convert those to his personal use. And to do that, though, he also had to fast talk staff and fast talk clients. And that scheme continued up until everything fell apart in the end. The other thing you have to understand is during this time, when he's earning millions of dollars and stealing millions of dollars, he's also borrowing millions of dollars from wherever he can, the bank, his law partners, his father, and it still wasn't enough. And this slow burn was continuing and continuing until the boat crash happened.
Okay, so right from the beginning, and I'll tell you this just for those of you guys who don't know who I am. I've been a trial attorney for going on 12 years now. Every single time you give an opening statement or a closing argument, I don't care how many times you've been doing this, you get nervous. You have nerves. And Creighton is settling in at this point in time. So you begin with a little bit of a script. I have no problem there. That's fine. You're a little bit nervous. You're jittery. You're moving around. You see him bobbing and ducking and moving a little bit because he's trying to settle in, and he does slow down. And even from the beginning, his delivery was slower than it has been throughout the trial, which I appreciated. And I think the jury probably did too. What I wanted to point at was this. When he flips this page, after he speaks on this page, so he's going through his notes, right? Look at how many words are typed on this page. Ready?
And stealing millions of dollars. He's also borrowing millions of dollars from wherever he can. The bank, his law partners, his father, and it still wasn't enough.
That is a whole page of information. I don't know how he was able to consolidate that or condense that into bullet points, but wow, that's a lot of info right there. And he's operating off of that for his closing. It's effective. I mean, he's got all the info in front of him to the extent he needs it. I just think it might have been a little bit too much, but let's see.
And this slow burn was continuing.
There we go again. That's a whole lot of pages. And you can see his hand shaking a little bit. Completely normal. That's completely normal. And I actually really appreciated watching him having some nerves. Because like I said, if you're an attorney, if you're a trial attorney and you don't get nervous, you're not doing it right.
Continuing until the boat crash happened in February of 2019. And that changed everything. That set in motion things that were going to happen because of the criminal charges related to that case, as well as the civil charges related to that case. And in the aftermath of the boat case, things changed. The pace of his stealing increased. In fact, that's when he stole the money from Tony Satterfield that you heard from. Ultimately stole about $4.5 million between the Satterfields and others. And unlike other cases, Tony Satterfield, who was the son of his longtime housekeeper, he took all the money, took every bit of it. And that was coming to a head as we move into the spring of 2021. Because there had been some publicity, and you heard from Tony Satterfield that he was the defendant reached out in the spring of 2021 because there had been publicity and saying, hey, I'm still working on the case. Everything's fine. I'm still working on the case. It's good. But the reality is the defendant didn't have that money to pay it back. And he had one saving grace because, as you've heard, they don't get paid until the end of the year. And his saving grace.
I want to replay this again. Because this as a motive started falling flat right about here. I want to be very clear on this one. I have been completely convinced Alex Murdaugh he's a liar, he's a cheat, he's terrible, he lies to everybody, he steals money from everybody. I'm not basing any of my conclusions in here on his statements one way or the other. I honestly think if I took every single statement he made as a complete lie, that I would still have these same opinions. What I will say when I back this up is this.
The reality is the defendant didn't have that money.
The reality is the defendant didn't have that money. So the inference that you are supposed to glean from that is that these murders were a way for him to deal with the fact that he didn't have that money. And the problem that I have with that is that there wasn't a whole lot of connect the dots on that particular point. He laid out the financial crimes very, very well. He did. He walked through them analytically. He had a PowerPoint. He walked through them. But it was very much along the lines of he didn't have this money and these things were coming to a head. And therefore, he needed to do something. And then you are supposed to infer the thing he did was kill his wife and son because he didn't have the money and these things were coming to a head. Well, two things from that. One, how do you make the problems go away? You either come up with the money or you make the problems disappear. Another method. There was no argument in closing that what he did anything to bring more money into the kitty. There was nothing in the argument made that essentially what was done would have increased his wealth to deal with the finances. So second part, making it go away. Did what he is accused of doing, murdering his wife and son, did it make the problems go away? What would the reasonable likelihood of those problems going away be after killing his wife and son? And I was hoping that he would make that connection, and we'll get there. We'll get to his argument on that point because I think it's pretty important. But right there, I wanted to pause because that was one of his big points that he wanted to make. So, and to this point here, Rock Blues, I see you right here. He wanted to become a sympathetic figure. He wanted to make it go away. I think you're right. I think there were more morning majority population do that. Yeah. So becoming a sympathetic figure, that can delay it. It can delay it. And when we get there, we'll go through. Because it doesn't make it go away. Even under Creighton Waters' own argument, it doesn't make it go away. And it doesn't really buy very much in the way of time. So it leaves me with a question. That's it. It leaves me with a question. I'm not saying it leaves me with a conclusion in one way or the other. It leaves me with a question. The thing is, with the prosecution's closing argument, I'm not supposed to have those questions. We're not supposed to have those questions. We're supposed to actually have a definitive explanation. So,
to pay it back. And he had one saving grace. Because as you've heard, they don't get paid until the end of the year. And his saving grace was the Ferris case, which they tried in December. They get the verdict and get paid in March. And that's when he convinces Chris Wilson to send those $792,000 of fees to him. But the problem is that only lasted for about 2 months. $792,000 only lasted for about 2 months. And then he's running out of money again. Meanwhile, you've heard in the boat case that Mark Tinsley was seeking to get a large personal recovery from Alex Murdaugh of $10 million because he thought, as many people did, that he was wealthy and had a lot of money. And when they said he didn't, he filed a motion to compel. And you've heard testimony about whether or not that had been granted, but it doesn't change the fact that that's what Mark Tinsley was seeking to do. And that boat case hearing had been scheduled for June 10th. In May of 2021, as we move into June, that's when Alex's own paralegal got the expense check for the Ferris case, but not the fee check, and tried to raise that to Alec and couldn't get a straight answer, tried to raise it to Chris Wilson and couldn't get a straight answer to his office. And so it goes to Jeannie Seconder, and Jeannie Seconder goes to the partners, and they can't get an answer about that either. And they want an answer to that because they're worried, because Alec has been talking about structuring fees, and they're worried he may be trying to hide assets because of the boat case, and they don't want to be a part of that. All of these things are coming to a head, and his finances are falling apart. And you heard from the banker there. You heard where his finances were at on June 7th, 2021. And you saw what happened in the wake of that. Within a short period of time, he was negative $347,000. On June 7th, 2021, he was in the office. He was working on the boat case, working on those financial disclosures, when Jeannie Seconder came in and confronted him about those fees that he no longer had and couldn't pay back. And on June 7th, 2021, and he tells this to Jeannie Seconder, his father, Randolph, is having a very difficult time. And while they might have said it was some positive news, the reality is that he was very, very sick. And he had always been someone that the defendant could go to, that he could borrow money from.
There were no insurance policies on him, on the kid, on Paul or Maggie.
And on June 7th, 2021, as all these pressures were mounting, the defendant killed Maggie and Paul. And how do we know that? We're going to talk in detail about that. But the timeline puts him there. The forensic timeline puts him there. The use of his family weapons corroborates that. And his lies and guilty actions afterwards confirms it. And we'll go over each of those in great detail. Before we get to that, though, I want to finish out, because in the wake of this, everything changes. all those things that were coming to a head immediately go away. It's a different world now. They're not asking about the Ferris fees anymore. And you heard testimony to that. Mark Tinsley doesn't believe the case is going to have the same value anymore because the sympathies of the case have changed after this tragedy. And you heard that. And who would better understand that than Alex Murdaugh, who does the same work? The boat case hearing goes away, and everyone immediately rallies around Alex Murdaugh.
It goes away for the time being. And Tinsley gives his opinion, which I take it for what you will. This is a part of the trial where there are going to be differing opinions on the interpretation of the evidence. And that's good. That's healthy. I'm glad you guys are having that thought and that debate. But from a pure factual standpoint, it goes away for a time, not indefinitely. It doesn't fix the problem. It essentially indicates that the problem is going to be kicked down the road a little bit. Is that sufficient enough motive, kicking the can down the road a bit? Is that sufficient enough motive to essentially execute your wife and son? People are making the observation that people have been killed for less and that people under pressure can do wild things. Yeah, you're right. You're right. I'm not disagreeing with you. What I'm saying is that is a piece of evidence that can be viewed in both directions. A lot of the evidence in this particular case can be viewed in both directions. So when I'm articulating the contrary point to Creighton Waters, it's not because I particularly believe that position. It's honestly because there might be a juror that could perceive it that way. And I wouldn't disparage them for thinking it that way. So let's keep watching for a bit.
And it worked because it allowed him to borrow $250,000 from Johnny Parker, his law partner, who of course
I'm sorry, because here's the thing. The other part I wanted to bring up here. Rob, are you assuming that Alex was completely rational at all times under immense stress and while seeking the drugs that Paul took from his pants? No, I'm not. Creighton Waters is. That's the other part of this equation. The state's case rests on two fundamental principles. One, that there was this gathering storm. And the suggestion that the gathering storm would cause someone to do things would cause someone to do things that would be in the extreme. The second part of Creighton Waters' argument that you actually have to buy it, you have to believe it, is that he was thinking logically, and that logical thought process is what led him to carry out what would have to be a very methodically planned murder. Regardless of the circumstances here, the idea that essentially he would have a break in that moment and not be thinking rationally. With how the timeline works and with how the staging would have had to have worked, you can't really believe both. He would have had to think this through. So which is it? Is he under so much pressure that he's not thinking rationally? Or was he thinking rationally enough to know that all of these things circulating in the background, this was the only way he could logically handle it? That's the point. You can't believe both of them at the same time.
Of course, wouldn't have loaned him that money if he knew what Alex was up to, and allowed him to go to Palmetto State Bank and get $350,000 in an off-the-books loan that hadn't even been applied for, and to send that money to Chris Wilson and convince Chris Wilson to pay another $192,000 of his own money, and to send an email to the firm that everything was okay. And that made it another month or so until Annette Griswold found that Ferris check in his office, and Jeannie Seconder looked up the forged accounts. What happened in the wake of that? What was the reaction of Alex Murdaugh? Within a day of September 3rd of him being forced to resign, his buddy Chris Wilson is trying to see him, comes and sees him on September 4th and confronts him about what he's been doing. And then within 2 hours, the side of the road happens. And Alex is a victim again. When accountability was at his door, he was a victim again. And he told a extremely detailed lie and went so far as to draw a composite sketch with the police.
Great use of prop. Because the logical part, it's the logical part. So this is what I was saying. Creighton Waters needs you to believe that he was thinking through this methodically, logically, and coherently. And this is suggestive of that. The idea that he would give a full-on sketch or give all the information to create a sketch for this alternate theory. Now, this happened after the murders, so give it what weight you will. But this is what Mr. Waters needs this info for. And this is a great use of prop because this is a very detailed sketch. And it shows you the level of specificity that Alex was able to lie about in providing this information to create an entirely different rendering. That's some effort right there.
Police of this assailant. And the accountability that had arrived at his doorstep again, he tried to get it to go away, and it worked for a little while. People thought, oh my gosh, what's happened here? Should we be suspicious of Alec anymore? But this time it fell apart a little quicker because his own brother figured out that he was trying to buy drugs. And the case fell apart very quickly. This is the setup for what we look at and what's going on. And it seems like a story that's far removed from most people's experience because it is. It is a different story like has never been seen before. But the reason is that he is a different man than the kind of stories that we've seen before.
This is a dangerous line of argument for a prosecutor to make. And let me tell you why. The prosecution is charged with convincing the jury beyond any reasonable doubt. They have to prove away all reasonable doubt. And what Creighton Waters is suggesting at this point in time is he's actually just putting the thought in the mind of the jury. I thought this was a bad move. That you have to look at this case as the exception, not the rule. That this is such an extreme and random thing, and he's saying that this is so outside the realm of what you would usually consider normal possibility that you have to give this a different view. And by doing that, the reason I say it's a tactical mistake is that essentially you are telling the jury that it would be easy to get to reasonable doubt. Because if it were a normal person or a normal case, you wouldn't even be here in the first place. So I didn't agree with him doing that in this closing argument. You don't want to automatically tip to the jury that in a normal case, we wouldn't even be at this point. So I thought that was interesting. I didn't really buy, I wouldn't have done it in that fashion. I know why he did it because you kind of have to a little bit. I just think that he could have avoided it in this particular circumstance.
This is a different set of circumstances than we've seen before. And it's certainly easy to understand when you have a middle-aged man who's outwardly successful, who has a strong family legacy, who has a prominence in the community and a reputation, but is living a lie. And that leads to and can lead to those pressures being overwhelming.
Another big boo-boo. And I know people are going to be mad at me for being hypercritical of this. I'm giving you guys essentially from a lawyer's perspective. This is the lawyer's perspective side. It can lead to. That's not the state's burden is not it can lead to. The state's burden is it did lead to. Don't put those types of questions in your closing argument. This is your chance to persuade. And by suggesting that it can lead to this thing doesn't necessarily mean that it does or it did in this instance. Putting that in your own closing is a dangerous thing to do. I think it might have been a little bit of a slip, but in either way, it was something that caught my attention pretty quick.
And actions like this happening. Husbands have been killing wives, unfortunately, for years, and husbands killing sons goes back as far as King Herod. Unfortunately,
here we go.
And actions like this happen. Husbands have been killing wives, unfortunately, for years, and husbands killing sons goes back as far as King Herod.
And right there, this might be a very, very, very bad move for Creighton Waters. He goes down the road in the second stage of this closing argument. He goes down the road of, why would anyone lie? Why would anyone lie about being at the kennel? Why would anyone lie at being at the kennel? Why would anyone lie at being at the kennel? Well, you know what you don't do as the prosecutor? You don't tell them why they would lie. And he does it right here. Husbands have been killing spouses for years. Fathers have been killing children and sons for years. It goes all the way back to history. Well, Mr. Waters, you just provided the jury with an explanation for the lie. One that you didn't actually have to do. You didn't have to provide that. I know why he said it. He wants to make it, seem like it's not outside the realm of possibility. But you just fed them the doubt in the lie. You fed them the reason why he might have lied. So, and then Ginger, I see you here. Trial Century is still a thing. It's still a thing. Just Murdaugh trial is pretty all consuming right now. Plus Ian has a conflict tonight too. So we're still doing it. We'll be back.
Probably for when those pressures mount and someone becomes a family annihilator. Now the computer input, please. All right. We got to do a little law school. I'm certainly not a professor, but we need to go through a few of the concepts here. And one of the most important concepts is the fundamental role, one of the fundamental roles while y'all are here. As the judge has told you, he's the judge of the law, but y'all are the judge of the facts. And what does judge of the facts mean? Well, a big part of that is that you determine credibility.
Yep.
You determine believability.
All true. You do. We're going to fast forward through the legal analysis because the legal analysis is he was fine there. No problem there. I didn't have a problem with any of his argument. It tracked the law pretty carefully. Let's fast forward to 2 hours, which is where he starts to go into, well, the PowerPoint, which is the bane of every freaking trial attorney's existence. Why are we still doing these PowerPoints? I get the PowerPoint, but why are we doing clip art in the PowerPoints? Just a comment. That's it. That's my little aside there. I don't really mind it. It just, the jury's sitting there going, can you just, like, bullet points of facts is great. Yeah. But anyways, let's fast forward to kind of him getting back on track after he does the synopsis of the law.
When he was at the scene with the victims minutes before they died and lied to everyone he would listen about.
Yep, he did.
A gathering storm. The boat case, other factors that were arising, each one leading to that inevitable day of reckoning. You had the trial lawyers conference where he was confronted. Mark Tinsley was confronted by Alec. Alec, of course, denied it. Everybody's lying on Alec. Alec's telling you the truth, even though everyone who knew him had no idea who he was. Everyone. No one knew who he really was. The people.
If you are in the jury box, and I'm just going to say that, I'm going to say this. If you're in the jury, I've made the comment on various occasions that Mr. Waters loved to get to that as his last question. Did you know Alex Murdaugh? Did you really know him? He wanted to ask that of every single witness because he wanted their answer to be, I guess I didn't. I guess I really didn't know him. And it's a cheesy thing, and sells for some people, doesn't sell for others. For me, it was him trying to fit a theme. Every lawyer, when we have a case, let me do this. There we go. Every lawyer, when we begin a case, you begin a case from the end. And where you begin trial prep is essentially from your closing argument backwards. You start with your closing argument and you come up with a theme for your case. What is the theme that I need to relay? It's kind of like a narrative or a book or anything like that. You need to be able to relay a consistent theme to that particular case. So you essentially strategize, how am I going to sell this? What's my punchline? What's the punchline I want to get to at closing? And how do I fit the evidence to get there? Now, Creighton Waters kind of telegraphs it here because he makes the comment in closing. No one knew him. No one knew him. No one really knew him. No one really knew him. Problem is that when you script your closing or when you have your closing, you really need to make sure the evidence lines up with that. And when you basically make this your theme, no one really knew Alex Murdaugh. Well, you need to have testimony that goes along with that. And I get that every single person that testified, Alex lied to them at some point in time. But how many of those witnesses that Creighton Waters put up on the stand that he asked that question to, did you really know Alex Murdaugh? How many of them actually said, no, I guess I didn't? One witness said no. Even Rogan, when he was asking Rogan the question, Rogan, who comes up later in the closing argument, Creighton Waters asked him, did you really know him? And Rogan actually comes back and says, well, yes, I think I did. So this was an example of his narrative, and it bled into his closing argument, but I don't think the testimony really lined up with what he was conveying. Other people are going to disagree. I'm fine with that, but we will take it for what it is. But it's kind of an example of why you need to be very careful when you're crafting your closing to make sure it aligns with the testimony that you're hearing.
People who came in here and said, we thought this about him, not a single person knew who he really was. That's how convincing he is. But he denies this confrontation. When Mark Tinsley was like, he bows up on Mark Tinsley. He's like, what you doing, man, about the boat case? And Mark says, you're going to have to pay money to the Beach family. Millions of dollars. Alex doesn't have that. He's barely one step ahead of the game at this point. He doesn't have insurance coverage anymore, or at least not a big umbrella policy. And why? Because his insurance company dropped him after the Satterfield case. Insurance company thinks the money went to the Satterfield boys, but it didn't. They don't know that he's stolen it all, but they don't want to insure him anymore. So he doesn't have that to help him pay the Beach case.
Oh, Laura, I don't know that that's fair. It's not that I fight. It's that I use the questions asked and the comments asked to raise the contrary point, because I do that regardless of the circumstance. I've been pulling up chats that are favorable to the prosecution and chats that are favorable to the defense. Just trying to aid in the discussion surrounding this, because a lot of people are divided on this one. I mean, where are we at? I put up a poll earlier today. Did the prosecution's case change? Did the prosecution's closing argument persuade you beyond a reasonable doubt? 38% said yes, 38% said no, 33% said no, 30% so far, with 2,900 votes in, have said still unsure, waiting for defense. That's an indication that people are still very divided about the facts. So I'm just trying to explain why people might be divided about the facts, because I can see it go both ways. I can see this one, he's guilty AF. I can see that one. I can see this one. People have different opinions. Yep. Majority of murders are committed by someone you know. Yeah. That all of these things are reasonable. So I'm not accusing the chat of anything. I think you guys are doing fantastic in having these discussions. And I've been very, very proud to see people in the chat engaging in a very positive manner in having these discussions and voicing their disagreements, because you can persuade people one way or the other. That's what the closing argument is supposed to do. That's what Creighton Waters is supposed to do in this moment.
And so what's the one hope he has? And that's the Ferris case. And it's tried, and we get a verdict in February of 2021, $792,000. And eventually he tells Chris Wilson, I'm going to structure those, which is a lie, and gets the fees sent to him in March. And it's spent in 2 months. But the boat case isn't going away. Mark says, show us your books if you're telling me you're broke. I think his testimony was, they said that he could probably cobble together $1 million, which I guess that's broke for him, but it wasn't enough. And so they refused, and that's what leads to the motion to compel. And there's been a lot of argument about, oh, is that going to be granted or not? Would the judge have granted it? What we do know is that Mark Tinsley said that's what he was seeking to do, and he was seeking to do it because he had been told by the defense that he didn't have money. So he's like, prove it. None of us believe that, knowing what we know about you in this community. Prove it. Well, Alec can't have anybody spinning his financial records because it's all going to be apparent. That forged account is going to open right up.
But they do. But they do scan the financial records. In fact, the second year did that day. The financial records are already there. This is why I'm having trouble with the whole finances causing or finances serving as the motive. Because the records are being scrutinized. They are. And regardless, because he goes into Tinsley and his motion to compel and whether it would or would not be granted. But the fact of the matter is a motion to compel had been filed and it doesn't just disappear. Now, I get the argument that sympathy will delay it or make the boat case less profitable. I understand that part. I just don't see the connection to the murder. That's my question. Hey, Ari. I just don't see the connection. And I wanted Mr. Waters to take this opportunity to draw that connection a little more clearly. He could have done it a little more impactfully. I just don't think I don't know that he did. Now, granted, a lot of this is before lunch. And after lunch, I think he becomes a lot stronger in his closing. So let's watch the wrap up of this. And then we'll get to the after lunch portion of his closing argument.
Mom found some pills and we need to talk. Another pressure from Paul and Maggie on him. And if you look at the texts, the weekend of the ball game on June the 7th, those are in evidence. Alec is not at the game. And he's texting back and forth, and Maggie's like, don't come if you feel bad. And he's like, well, I think I can get a late checkout. And then he's like, at 1 o'clock, they made me leave. I submit to you, it's a reasonable inference they were on him at this time.
See, there, that's a good argument. That is a good argument. And I think that with that argument, the drug use, that is one, had he focused on that more intently, I think it would have been more persuasive. I don't know that it gets me to that's the idea of why he would kill his wife and son. But at least that one, he connected the dots. The day of the game, or the day of the game, he doesn't go to the game. They kick him out at 1 o'clock. He's not feeling well. You have the drug use coming up to the head. But this amounts to about 5 minutes of Creighton Waters' closing argument, with the rest of it being finances. I was frustrated by that, just because I understand there were dozens of victims of Alex Murdaugh. There were dozens of financial crimes victims. He stole money from people, and it is disgusting as an attorney to hear what he did in betraying the trust that his clients had in him. But it is hard for me. The other point that I have seen people make comments about throughout the interwebs while watching this trial, of how Mr. Waters is speaking for all the victims of Alex Murdaugh. That is a problem. That is a big, big, big problem. Because this is not the trial for those victims. This is not. And to be quite fair, trial is not really a place where justice is meted out and the victims feel vindication. Trial is to convict the accused. of the crime with which they are accused. This is a trial for Maggie and Paul's murder. This is their trial. Respectfully to all of the victims of his wrongdoings. This is the trial about the death of two people, Maggie and Paul. And the financial crimes will see their day in court if they need to. If it's pled out and he gets sentenced for that. If he pleads out and gets sentenced for that, that will be the justice for those victims. But this is a trial about Maggie and Paul. And when you're reciting the things about the other victims, it honestly, in my opinion, being a trial attorney, it takes away from Maggie and Paul's murder. It's difficult for me to hear a lot of people going out there and saying that this is for all the victims. It's a murder trial. It's about two people who are no longer on this earth. So I got frustrated by some of that. So we'll get to the end of his the financial closing. We're just going to call it financial closing and murder closing.
They were watching him like a hawk. Opiates, the most powerful of withdrawals, and everything's coming to a head, including this as well.
Better argument. I liked this argument. It's better.
Run out of money, running out of options, doesn't get paid in any significant way until December, already stole the fares fees and spent that money in 2 months, has an expensive pill habit, and accountability and consequences will undo everything in his life, everything that is his self-identity, everything, the only things that he cares about. He doesn't care about lying to his partners and his family and his friends and his clients if it will delay accountability for him. He'll do it in a heartbeat. And all of that is about to be undone.
We have a good stopping point.
Yes, sir, Your Honor.
Love this judge for doing that. Basically says, we're at lunchtime. It's lunch. We need food. Food is great. Food is good. So while we switch over, let me do this. Let me pull this down, answer some questions, and we'll switch over to the afternoon stream and go from there. Do the things, switch that off. Before we go to questions in the interim, I do want to say, please, if you guys are here for the first time, please like the video. It really does do a whole lot. Do the YouTube things. It's great. I love this channel. I love getting to talk to all of y'all. It's honestly really a cool part of my life, and I love spending this part of my life with all of you and discussing and trying to educate where I can. So if you don't mind, hit the like button. If you like the content, if you like what you hear, hit subscribe. We're going to keep on covering the Murdaugh trial, other trials, so I would very much appreciate that. Let me do a little, because people are going to be mad at me if I don't. We'll do a swoopy swoop, answer some questions, and we'll get to the afternoon session. So swoopy swoop. Is that a cat riding a unicorn? Yes, it is, because, well, reasons. So we'll do it one more time for good measure. Oh, gosh, it's fun. Okay, questions. Let's see. We'll pull one real quick here. Creed, thank you. Question: can you claim Alec lies his whole life and then say there's no reasonable doubt about the only reason he would lie about kennels being that he killed them? Can you claim Alex lied his whole life and then say there's no reasonable doubt about the only reason he would lie about the kennels being that he killed them? I don't know. Let me go backwards on some of these. Has Alex Murdaugh pled guilty or not guilty to the other cases? Not yet. There's been one plea deal, and I think it was in the civil case in the boat, but the other financial crimes are still pending. They're still being prosecuted. K-Bragg, thank you. I think they spent too much on the financials because they have to show him to be a monster. Jury will acquit him if they think he's human. I think that's a fair assessment. I think that's how Creighton assessed that as well. Crumfeld, thank you. Crumfeld is an attorney, by the way. I love getting input from attorneys in the chat because I like having conflicting opinions, both from people that are non-attorneys and people that are attorneys. I'd have objected to closing RE 1,000. Oh yeah, we're the 1,000 milligrams a day and being lethal and crippling. No evidence about that ever in the trial. If CW believes all this, state South Carolina should never see DP against anyone if it isn't a DP case. That was an interesting part as well. Creighton Waters goes and toes the line on a couple of these arguments where he starts to infer things from the testimony that wasn't really there. I expect this from Creighton Waters and from Jim Griffin. Both sides of this case have kind of played a little bit fast and loose with what the facts show. So yeah, thank you, Crumb. Jelly Roll, financial victims may never get their day in court if he pleads out. That is not what trial is about. Trial is not for the victim to get their day in court. Trial is for the state to put on the case and to convict the accused of the crime they have done. That, and whether it's a trial or not, a guilty plea to those charges is a finding of guilt. That is the justice that those individuals are entitled to, the finding of guilt. That is the purpose of trial. Yeah. Jennifer Johnson, but if the prosecution argued the drug problem as the motive, would he have been able to get the money crimes in? He snuck those in backdoor. He did. He snuck them in backdoor, and he's using them to try and make the argument bad man do bad things. It's interesting, and whether it sells for the jury is up to the jury. I think a reasonable jury could reach the conclusion bad man does bad things. I only have an issue with that because it's not technically how the system's supposed to work. Melissa McAfee, question. Creighton gave what seemed like partial jury instructions today. Will the judge give formal instructions? Yes. Or in South Carolina, instructions left. No. Judge will give the instructions. And Creighton Waters does make it very clear the judge will instruct you on the law. They are allowed to argue the law because they need to argue the law. They need to argue how the jury should interpret what the judge is going to tell them. So yes, that was completely proper. Dana Blackwell, thank you for your guidance, interpretation, wisdom. You are a straight shooter. No reference to this case. Thank you. Intelligent guy with a gentle side and makes you easy to follow. Thank you very much, Dana. That's very, very kind of you and very much appreciated. Christy, thank you. On the one hand, Creighton Waters talks about Alex Murdaugh being a lawyer and a prosecutor, so he does things like use two guns, make him an alibi, then argues that premeditation only takes a second. Which one, Creighton? It was an interesting argument, and you shouldn't be posing questions to the jury. You should be telling them how they should interpret the evidence that's been presented. Sandy R., thank you. Not necessary to prove motive. If it helps in the case with direct evidence, but not required. Who knows why AM does any stuff that he's admittedly done? Exactly right. And I saw other questions in this regard as well. The prosecution is not required to prove a motive. They are not in any circumstance required to prove a motivation to a particular crime. That said, once they put forth evidence on a motive, once they have adopted that as part of their narrative in their closing, they have adopted that as their narrative. And anything that they say in furtherance of that argument can be undermined if people aren't believing the motive argument. If people don't believe the motive argument, then are they going to give the same weight to the argument being relayed with regard to the actual murder itself? I don't know. That's why I said it was dangerous. Solo Yolo, agree with A.L. Both sides know their jury. It's possible. I think they might. C Minor, thank you. C Waters looks like Tim Conway, and he did great. That's a good opinion. I thought he did pretty well. I didn't think it was terrible. I thought he did pretty well. He definitely toned the pace down, and he did a good job presenting. Lauren Cove, happy Wednesday, Rob. New sub and love your channel. Thank you, Lauren. Very much appreciated. Glad to see you here. Magical Mary, Rob, I appreciate your legal knowledge and that you share with us so we can debate. Thank you very much, Magical Mary. There's not enough actual informed and thought through debate and discussion anymore. And I love being able to provide a little bit of a forum for us to do that. I think one of the things that we've lost in the past several years has been the ability to disagree respectfully. You will see any number of the lawyers on YouTube argue and debate. And the cool thing about it is we walk away from that still being the best of friends. So I hope that's an example to others. Connie, what is Trials of the Century with Ian? You two are wonderfully entertaining and don't want to miss anything. Trials of the Century, TOTC, is a series that we do where we go through old historic trials. For example, the trial of Lizzie Borden, which kind of has a little bit of relevance here because Lizzie Borden, you might remember from the nursery rhyme, Lizzie Borden took an axe, gave her father 40 whacks when it was she was done, gave her mother 41, something like that. I forget the rhyme itself, but that trial, we covered that in Trials of the Century, historic trial. One of the interesting things about that was blood. There was none on her, and it was interesting, but she ended up getting acquitted of that one. But yeah, it's a good series. Check it out. It's in my channel, and you can see it on Ian's channel as well. Bears Halo, aren't financial restitutions being made or have been made by the prior law office? They are being made as we speak. AL, state is tailoring its case to this jury. As a lawyer, I have many criticisms, but as a low country native, I see how he's connecting with these jurors. And that is a completely fair assessment. When I give this interpretation, it's me as a lawyer, not so much me as a juror. So I'm not in this jurisdiction. I can't comment to what is going to work in front of a South Carolina jury. Jacqueline Nash, thank you. Can the jury find guilt but not because of why they say? Yes, they can. The jury can find anything they need to or want to. The jury is the one who gets to decide the facts. Example, I think Maggie would have divorced him after the money crimes came out, so he avoided that cost and humiliation, and Paul's crash started it all. So not a sympathy distraction. Interesting interpretation. I think that might have some weight to it, maybe more than the financial crimes issue. But yes, the jury can find anything they need to. Moffat on Money, glad to see you here, my friend. Enjoy your thoughts and comments. Also, check your Twitter DM. Going to be in the area. Want to buy you a scotch or Malort? Nope, you're not allowed to buy Malort, but we can have a scotch. No problem. Moffat, I'll check that as soon as the stream is done. I'd be glad to have a drink. Jill, no insurance, but no Paul equals better boat case outcome. And no Maggie gets all the assets moved to her, would go back to him. It's a stretch, but possibly. Yeah, but there's what you heard in the testimony was it would actually be harder for him to monetize that and use that in an expedient fashion. Creighton Waters made the comment that he had to deal with these things quickly. The estate administration process is anything but quick. Anything but quick. So it's interesting. Heather, thank you. Does the state have to show why the murders happened? Just that Alex did it. The state does not have to show why. They just have to show that Alex pulled the triggers. Eleanor, thank you. I think if it were not for Buster, he would have admitted his involvement by now. Buster would never forgive him. Forgiving theft is nothing compared to the loss of his mom and brother. That's an interesting take. Yeah, okay. Tim Harris, lots of terrible crimes have obscure motives. The argument should just focus on the impossibility of an alternate theory at the kennels. He tried that. He does. And we'll get to that because I do want to go through the timeline. I was begging for the timeline evidence and I needed to hear the argument on that. And I do want to hear that through to conclusion. Marjorie, thank you. Question, wouldn't the money stuff be uncovered anyway with her estate settlement? Yes. She owned property. He would know that. Motive makes zero sense to me. Marjorie, you are not, I don't think you're far off. That's kind of my take on it. And maybe that's me being the lawyer and reading some of the lawyer into this. But, and I don't know the defense argued it as well as they could have. But being an attorney, having handled estate administration cases, all of these things get uncovered. All of these things get uncovered. The idea that he was doing this to cover this up is almost, it almost borders on ludicrous, because once that thread starts getting pulled, there is no unpulling that thread. That's the point. That's my point here. When he knows the thread is starting to get pulled, I think if anything, that decreases the motive for a killing and increases the motive for perhaps something else. St. Elmo's Fire, thank you very much. Murdaugh are big Clintonites, Obama and Biden supporters. Do you think Biden will pardon him on financials and presidency? I don't know. I really don't. I'm not going to dig into the politics of these individuals. I really am not. I don't read into that in that same way. Melissa Marquez, thank you. What stood out to me the most? AM said the dogs were not alert or hyper. No one else was at the kennels or in the woods. He puts him by himself with family. That's true. Joe Tracy, I have very much appreciated the fact that you have been respectful in this chat. And I know that you have an opinion that's contrary to a lot of others here. And I very much appreciate how respectful you've been. Please continue doing it. It's wonderful. That's why I highlighted this one. Creighton didn't have the time to wait to go to trial because of the financial crimes. If they had been prosecuted first, the state might not have bothered with this difficult case. Creighton wants justice. That's a fair interpretation. It's a fair interpretation of Creighton's actual motive. I don't know if that's why he did it. It might be why he did it, but I think that it doesn't really hold up to a legal, like when you put it to legal scrutiny, because the financial crimes being tried first would have allowed for a lot more time to do additional investigation. For example, the GM data would have come in. They could have pushed that issue harder and they would have had that to build their case stronger. Do more interviews, find additional information, and kind of head off some of the defensive arguments. But it's a good comment. Thank you, Joe. Diana, capture the tie. Conti, do we vote for Rob or Ian? The capture the tie is a fun game that we have started playing. Alan Fortenberry, thank you very much. I'm not sure the prosecution can call the investigation in this case exhaustive. I would be inclined to agree. Lynn Bell, don't know if AM is guilty or innocent yet, to be honest. Hope whomever did this is brought to justice because Maggie Murdaugh and Paul Murdaugh deserve justice. 100% agree. The surviving family members will hopefully be able to move forward. I very much agree with that. That surviving family members, I hope, are able to move forward after this trial. Nine Inch Nails gal. Creighton didn't walk through the financial crimes. He dawdled worse than a donkey with no carrot in front of him. It was a slow and methodical, and the PowerPoint was there for the financials, but it was a lot. JR, I don't think murders are typically very logical. That's an assessment. Ryan Man, YYC, I think that's my reasonable doubt question. How do the murderers solve his problems? I come up blank. I think that you're not alone. Rock, Blues, and Barbecue. I also think shame is a very relevant factor here on how he destroyed everything around him. Thanks for reading my previous comment in your coverage. Rock, Blues, and Barbecue, thank you very much for the comment. And I think the shame is a relevant factor. I think Creighton brought that up pretty well today. The whole this is the family pride moment. I think that was pretty strong. One of his stronger points. And as far as the last part, I do try to bring up comments. The chat moves pretty quick, so I can't always catch them, but I do try my very hardest. The world wonders. Thank you. The pattern when financial scams collapse is usually do more and more desperate things to buy shorter and shorter amounts of time as options run out. Always about that next temporary relief. That is a fair take. That's a fair take. And the question is for the jury to say, is the murder of your son and wife the next thing in that line of things that you need to do? Okay, I don't want to get too far behind, so let's go ahead and pull the beginning of the afternoon session of closing argument, go on that, and then I'll pull up some of these chats as we move along. Let's see, share the screen. I did star super chats. I will get to all of those, I promise. I just want to make sure that we're moving along. So let's go forward with the afternoon session.
You may continue.
May it please the court, Your Honor. All right. Hope everybody had a good lunch. Motive, means, opportunity, guilty acts. That's the basic way you determine identity. So let's talk a little bit now about means, the tools to commit the crime. Family weapons were used to commit this crime. And this is forensic evidence that was presented to you. First of all, we'll talk about the blackout. And you've heard testimony that there were 2 blackouts purchased in December of 16. And that one went missing around Halloween of 17, years prior to these murders, and that a replacement without a thermal scope was bought in April of 2018. 3 blackouts that the defendant purchased can only account for one of them. And it's this 3rd blackout, which is the one that's at issue. You heard from Paul's friend, Will Loving. And first of all, let me say this. You heard the defendant in his various statements, and he's very concerned about saying that they didn't have a blackout. There was no blackout along with them, even though he slipped up once and said, yeah, we were out looking for hogs. And you heard from his law partners that do the same thing, saying, yeah, you can look for hogs in the daytime. Very, very concerned early on in the statements and saying they didn't have a blackout. They just had a .22 pistol. And he also said, eventually, he's like, well, I think I replaced it. I guess I replaced it. I'm certain I replaced it if you listen to his various statements. Very vague and fuzzy about this 3rd blackout. Until the friends, Paul's friends, both of whom testified, but Will Loving in particular. And what did Will Loving say? The defendant said the gun went missing around Christmas time of 2020, but Will Loving said, no, I was with Paul. I was with Paul in turkey season, which is in the spring. I was with Paul in turkey season, and we sat out at the steps right outside the house that y'all went to today, right on that side entrance that goes into the gun room. And if you look down, you can see how they were digging a pond and how you could fire down in that area. And they set up some targets to sight it in. And we were shooting that other gun. We were shooting that other gun, that replacement gun. And it had a red dot sight on it, not a thermal scope, but a red dot. A red dot, which is not good at shooting at night. But they were shooting it and sighting it in with the red dot, the tan gun. He was with Paul while they were shooting that gun right there. And what did Jeff Croft, who testified before you, find right there? Weathered cases or casings. Weathered cases right where Will said he and Paul were shooting that gun just a couple months prior to the murders. S&B 147 grain blackout rounds. And those rounds and empty boxes, and the pictures are in evidence, and the rounds are in evidence, were found all over that property. S&B 147 grain blackout. There were full clips found, there were empty boxes found, and there were also cases found, S&B 147 grain blackout rounds found across the street at their shooting house. Two separate locations on the property. But what's really important, again, goes back to what Will said. I was with Paul when we shot that replacement gun right there. Right there. And you heard forensic scientist Paul Greer testify that the 6 cases, items 2 through 7, the 6 cases found around Maggie that killed her were loaded into, extracted, and ejected through the same firearm that fired those weathered cases right outside the door where y'all went to today and at the shooting range across the street.
Okay. So this begins the part where I start objecting in my mind to some of the closing argument. This is a bit inconsistent with what Greer testified to. And I'm going to pull it up again after this stream is done and try to figure out and rewatch that testimony. But here's the thing. Greer is the toolmark analyst who testified to the extraction and firing pin markings on the casings that were located around the property. And what Greer said was he could testify that these were similar or consistent with rounds fired out of the same weapon. He cannot testify to a certainty that these rounds were fired from this particular weapon. Be mindful that this is toolmark analysis is something that, well, I've talked about it before. It is science that has been used to wrongfully convict people for a long, long time. I hope the Supreme Court takes it up. I hope we have an issue with it. I hope they actually can resolve it. But it does not hold the weight that is being offered here at trial. And I hope the defense, I don't mean to say I hope the defense argues that, but essentially it's a measure that says looks kind of like. I've used the analogy. You guys ever see the Pantene Pro V commercials or any of the hair care commercials where it shows the hair strand before using my product and then the hair strand afterwards, and it shows the comparison side by side, and you say, well, it looks pretty similar. That's what it is. Now, here's the problem with that. In the age that we are in right now with CNC milling machines, these CNC machines are essentially accurate down to the micrometer, like they all the way down to almost zero tolerance issues, which means that the same manufactured weapons, the same manufactured firing set, the same manufactured ejector are all going to leave almost identical marks. This was a bit of a misstatement of Greer's testimony, and I didn't really care for it. It bothered me a bit, because it was the first time that I saw Mr. Waters kind of tiptoe that line of whether the recitation of the testimony is going to be accurate or not. This one kind of bothered me a bit. And he goes on to talk about it because he relays it as being so conclusive that these are the rounds fired from the same gun. It's not really what the evidence said, especially after cross. He's picking and choosing from the best parts, and this leaves an opening for the defense to argue that in their closing. So we'll see. But this one was kind of a gap that Mr. Waters brings up in his own argument.
A family blackout killed Maggie. It was present just a couple months prior to the murders. It's gone now.
That's fair. See a minor.
It's gone now. A family weapon the defendant cannot account for killed Maggie.
Right there. Also objectionable. Boom. Objectionable. The defendant cannot account for. This is a shifting of the burden. The defendant does not have the obligation to account for anything. The state has the obligation to prove that this particular weapon did this particular crime. And the state has the obligation to put that weapon in the defendant's hand. You can't simply infer that because the defendant, who does not have the obligation to produce the weapon or produce a weapon that doesn't shoot the same rounds, you cannot infer and shift the burden on them to do it. So that one bothered me quite a bit. That one bothered me because I get the implication, and I do 100% get the conclusion that people reach, and it's a very natural conclusion that you should be able to account for the weapon. If you can't account for it, then it clearly, you had it, or you did away with it, or you threw it away. That's not an inference that the law really allows you to make in a criminal prosecution. You're not supposed to attribute that to the defense. That is on the prosecution to prove. Now, the reason that he's able to kind of skirt this and get away with this is because of statements made by Mr. Murdaugh. Alex Murdaugh makes various statements throughout his different interviews. Again, why you don't give statements, because if you tell one lie, it can come back. They essentially use those statements to say he couldn't account for it, because he says in those interviews, I can't account for this gun, or that gun was lost. But the argument, I thought, was a little underhanded. Now, I want to be fair here. The defense is very likely to do the same thing. A lot of attorneys, when they make these closing arguments, will do the same thing. They will skirt the edge of where the testimony was and what they're trying to get the jury to infer from that testimony. It's their job. It's just tough. And it goes to show you why a lot of attorneys are on their toes when they hear closing arguments like this. Because it's very, very, it's tough. I have put Dick Harpootlian and Creighton Waters, those two individuals, in similar camps as being essentially the types of attorneys that I have the most difficulty with in court, because they love to argue what was said while not really repeating verbatim what was said. That kind of bothered me.
But what about the shotgun? The 12-gauge shotgun that was loaded with one federal double-aught buck and one dry-lock #2 steel shot. Well, first of all, you heard that the two weapons that Paul often favored and often carried were this shotgun right here and the blackout. Those were his.
I want you guys to notice how he presents the shotgun. At every other step in this trial, I pulled up another one where they pull that shotgun out. The strap is not on it. But in closing, the strap is on it, because he wants the jury to see the strap. He wants the jury to think that, or to infer from the strap being present, that this could have been strapped over his shoulder. It was very, very fascinating. And it just shows that Mr. Waters is quite bright. He knows what he's doing. It was clever to watch.
Were his two guns, his favorite guns, aside from his deer rifle. The defendant had that gun with him when Daniel Green, the first deputy on the scene, showed up. And shotguns, as you heard, are a little bit different than rifles. And the conclusion there was that the two fired shells that were inside the feed room that killed Paul had class characteristics similar with that Benelli, Super Black Eagle 3.
Sorry, Mr. Greer, but I'm going to keep just because it's that class characteristics similar to those of the cartridges that were fired. You all know what that means? Let me translate it. Class characteristics similar. That means that it was either in the same category as every other semi-automatic shotgun, because the ejector is going to cause a similar marking. It's the same thing as saying that I found something that was the same class characteristic as every other break action shotgun or every other pump action shotgun. Class characteristics means that of a category, it's a shotgun. That's a semi-automatic shotgun. That's what he's saying. That's what this testimony is. But the inference that he's arguing in this moment is that its class characteristics are so closely tied to this particular shotgun that it must be this particular shotgun. That part I did not like. That is a stretch. That's a stretch right there. Class characteristics. You know how many semi-automatic shotguns they had on that property? A whole lot. How many semi-automatic shotguns there are in the world in general? A lot. That's what that meant. This was a semi-automatic shotgun. A little bit of a disingenuous argument.
But insufficient individual identifying marks to either match or exclude it. That shotgun right there. But what else did you hear about the shotguns? Paul had the Spinelli Super Black Eagle 3. That was his gun. Camo print, camo strap. Nolan Tootin, Nathan Tootin, Will Loving, Rogan, all identified that as Paul's gun. It's the one that Alec had. It's got Maggie's DNA and blood on the receiver. You heard from the DNA expert. And it was loaded with 12 gauge and a 16 gauge misloaded round. What else?
Lorna, when this so your comment was it's not true they cannot exactly match the shell casings. I am telling you that science tool mark analysis is with all, I'm telling you right now, this is up on appeal in various jurisdictions. This tool mark analysis will go the way of the dinosaur in the next 2 to 5 years, guaranteed. It is no longer valid science. It is junk science. It really is. And I know that there are people that still, I know it's still used. I know it's still allowed to be used because historically we've allowed people to use it. We've allowed it to be used in arguments. This science is going the way of the dinosaur. And talk to any firearms expert about it. I've talked to several, beyond several, including various very, very, very prominent forensic societies who have filed amicus briefs in these cases arguing that this should no longer be allowed as evidence. Yeah, the tool mark analysis needs to, yep, Becky, bite mark analysis, same thing. Yep, that's what it is. Same thing.
What else did you hear? You also heard about the Super Black Eagle 2. And you heard from Nolan and Nathan that this was Buster's gun. This is the Super Black Eagle 2. It had the Mojo sticker on it. And that was recovered during SLED's search of the residence the next day. What else did you hear?
I'm sorry for the constant pauses. I'm sorry for the constant pauses, but this is another one. He literally just said, why are you showing the jury in your closing argument 2 different shotguns? Why? Tell me why. You have to prove the gun that was used. Why are you giving them 2 alternatives? You're doing that because you're suggesting that maybe the first one that you argued was the weapon, but the second one might also be it. That part that right there. Mr. Waters, you didn't have to do that. You did not have to do that. That's a misstep, sir. That's a misstep. He's showing two alternative weapons. Thank you, Julie. He's showing two alternative weapons because he's not sure what weapon it is. And he's hoping the jury reaches the conclusion that if it wasn't this one, then it must have been that one. The problem is that that's not his burden. His burden is not to say it could have been this one or that one. His burden is to prove beyond any reasonable doubt that it was this weapon that was used. So that part is a problem in this case. So let's do this. We're going to fast forward to some of the timeline, and I want to watch that in some level of detail, and then we'll comment on it here and there. But we're going to end with the timeline. We're going to fast forward to the very end of his closing, and then I'll give a little recap, and we'll go from there. Make sure I've got my timestamp correct on the forensic timeline. Family weapons. Where's my mark? Where's my mark? Where's my mark? There we go. Let's do this. We'll go to 4542.
We have creation of a Snapchat video that had clothes on it. When that ultimately was recovered and you saw the interview, it was shown to the defendant, who had provided his clothes that night. And at the first time, then he started talking about changing his clothes, and we'll talk more about that later. Again, 7:55 to 8:05, we have some symmetry with the steps. We have Paul Murdaugh's battery life, and you heard from the experts that have reviewed Paul's usage. That, like many kids his age, he's constantly flirting with it being low. That doesn't stop him from using it, and you see that in the evidence.
Pay attention here. This, I think, is another misstep in the close. Creighton highlights symmetry with the steps. Creighton highlights symmetry with the steps in the two phones, Alex and Paul's. So he's highlighting. Teresa, I see you. I see you. No, I try to pull all the chats, Teresa. Thank you for being here. I very much appreciate it. It is really very, very much appreciated. I try to do it, and I try to see all these chats. This by Creighton Waters is highlighting the symmetry in steps. The problem that becomes is that symmetry ends. And there's an explanation as to why. There's something you can draw, an inference you can draw that the steps don't line up because he's turned his phone off. But why would you highlight that there was symmetry to begin with? I just don't think it was a good thing to do.
The evidence in this case as well. 7:56 again, that's when Paul sends the Snapchat to his friends. And then at 8:08, we see Paul leave the kennel area at 8:06, and 8:08 make his way down to the residence. (8:05 to 8:09). Around that time that Paul is getting there at 8:08, that's the last step activity on Alex's phone. And it's the last step activity until 9:02, which we'll talk about in a minute. Alex's phone pretty much goes with no activity for that time period.
It's weird.
And also, he has no cell activity from 6:52 to 9:04.
That's really weird.
Right in that time period.
Right.
We'll talk about it in a little bit.
Everyone's right. That's very weird.
So, eating dinner. You heard the defendant talk about eating dinner. Paul is at that residence, if you look right here, from 8:14 down to 8:35. And again, that timeline exhibit, there's a big one and then there's a condensed one. And all of this is in there in evidence for y'all to look at. He's at that residence from 8:14 to 8:35. Now, the defendant, again, despite having a photographic memory, a new photographic memory about things that he told y'all that people are hearing for the first time, still can't remember specific things about Maggie's activities, as to when Maggie arrived, as to what they talked about. He can remember dropping his phone down in the console, but he can't remember things like that. He wants to remember things that help him try to explain to you why he never told the truth about maybe the most important thing he could tell law enforcement. But he can remember very specific details. He still gets this wrong. But she arrives at 8:17 in Moselle. They're already there. How do we know that? Because her cell phone.
You have to appreciate Creighton Waters for the shade. I thought this was great argument. This is a great argument that he makes. This newly found memory. Now, he says it a lot. He does. He does over and over and over again. But it's a proper thing to do. When you have this new narrative, you actually have to basically argue that this is brand new. And he does a good job at it. Throws shade right in that direction. So, yeah.
Phone disconnects from her Mercedes at 8:17, and that's when she starts showing steps. And Paul, what's he doing? He's still using his phone like always. We see the battery life, but he's still sending snaps, he's receiving snaps. Bless you.
Side note, I made a comment while this was happening live. Kudos to Creighton Waters for saying bless you and blessing that sneeze. That good on you, my friend. That shows that you're aware of your surroundings and the attention to detail is appreciated by at least me. Wonderful. I'm going to fast forward a little bit or just go to 1.5. I know that's going to frustrate some of you guys. He is talking slowly through this, but it is important that we get through as much of this as we can. I can't watch it at real time because it's already been an hour and a half and I want to make it through the good part. So let's continue onward.
He's sending to his friends, all these friends right here. He's receiving these snaps all during that time from 8:17 to 8:30, continuing to communicate with his friends, using his phone like always. And then what happens? About 8:30, Maggie's phone registers some steps. And consistent with that, consistent with her and Paul going down to the kennels, riding down to the kennels, we see Paul's Murdaugh's phone start showing steps. And then down here at 8:38, he's in that kennel area where those dots are. And if you look at that particular slide from 8:38 to 8:44, that's going to be the last GPS reading on Paul's phone, 8:43. You heard from Rogan. You heard from Rogan as it references this timeline. And Rogan tells you and told you from that witness stand that he was having a conversation with Paul about cash and the dog's tail. They were having an active conversation about that. Paul calls Rogan at 8:40 and they're talking about it. And Rogan says, send me a FaceTime, but if it doesn't work, send me a video. At 8:44, 4 minutes and 14 seconds, we have right here the FaceTime, but it only lasts 11 seconds. And then at 8:44:55, that's when the kennel video was recorded, that last 50 seconds. At the beginning of this investigation, as you'll recall the testimony, they didn't have Paul's password and couldn't get in. And you heard in the defendant's August 11th statement that when he was asked about Rogan saying he may have heard Alec on the phone during this time, he said, well, I'd be surprised if that were the case. Because law enforcement didn't have this kennel video. They didn't have this kennel video until April of 2022, when Paul's phone was finally unlocked. And that changed everything. Why did it change everything? Opportunity. Being at the scene of the crime when the murders occurred. Opportunity. And more importantly, exposing the defendant's lies about the most important thing he could have told law enforcement. When was the last time I saw my wife and child alive? Why in the world would an innocent, reasonable father and husband lie about that? And lie about it?
Right there. That's the point I made from the very beginning when I highlighted that one statement he made in closing. And I'm not saying anything about the why would you lie. I think this is a good point to make. Why would you lie about something so significant? Fine. That's fine. But don't give them an answer. Don't give the jury an answer that's different from the one that you need them to reach. Example, husbands have been killing their spouses for years and years. Fathers have been killing their children back to ancient times. Don't ask the massive question when you've given a possible answer already. Because this could undermine, you're undermining your own argument. You're undermining your own argument. That's it. That's the problem. This is just a tactical decision that I think was a misstep with that one comment, that one question, or that one statement rather. So it's just a point that if there was a juror that heard that and it stuck with them, then they're going to hear that, and that's going to continue to echo in their head as they're hearing Creighton Waters make this question and make this question a big issue. So what I'm going to do is we're going to play this now, and I'm going to give you, I'm going to do something, because I'm going to end the poll that we have currently up. Here's where we are right now. The poll we currently have up has 4,273 votes. There are currently 3,318 of you here. If you have not liked the stream, please do so. I very much enjoy these recaps. They're a lot of fun. They're difficult to do, but they're a lot of fun. And I like giving you the input as the day is there while it's still fresh in your minds, and you can actually get a little catch up on it. So please like the stream. If you like the content, please subscribe. We're slowly working our way to 200,000 subscribers. And by the end of this trial, I mean, we're still going to do some more recaps here. We'll get there. So thank you guys for being here. Very much appreciated. If you can do the YouTube things, I will very much appreciate it. When we get to a specific point in Creighton Waters' recitation, I'm gonna highlight something, and then we're gonna do an experiment of our own. But I'm gonna end the poll right now, and the poll ending says, did the prosecution? What was it? Did the prosecution closing argument persuade you beyond a reasonable doubt? 37% of you said yes. 33% said no. 29% of you still said unsure. That is 4,300 votes. That is a pretty big divide. And if I'm the prosecution, I don't like those numbers. But again, I'm not doing this in South Carolina. I don't know this jury. So we'll see how that holds up.
About it so early. He didn't know that was there. And he could always say, well, Rogan must be mistaken. I'm surprised. Not if my times are right, was what he said. Rogan told you I was expecting that video right there. That was supposed to be the next thing that happened. Send me the video, because we were worried about Cash the dog's tail. He talked about how his girlfriend was going to call a veterinarian, or she had some association with one. There was an active conversation going on right then and right there. And what's going on still? Paul's still also texting his friends. You might recall that in opening statement, the defense counsel said, oh, he was texting after that video for 10 minutes. It's not for 10 minutes. It's for barely a minute. Down here, 8:48:58 to 8:49:01. That's the last time that Paul's phone was unlocked.
Here's our experiment. So I have my phone set on a timer for 21 minutes. 8:49:01 is the time that his phone locks, quote, forever. 9:06, the car is driving off of the property. By my math, that's still 21 minutes. So let's do this. Was it 21? So 8:49, 50, let's say 8:40. Yeah, that's 21 minutes. So we're going to do this. I have my timer set for 21 minutes. We're going to watch the testimony, and we're going to watch, or rather watch the closing argument, and we're going to get back to that. But I want you to listen to when that timer dings, and I want you to kind of visualize in your head at this particular moment that certain things are taking place during this time. At this particular time, Paul is inside of the kennels filming a video of the dog's tail. So he's still inside the kennels. You hear a hose in the background. The hose has not been put away. The hose is still being used in the background. And you hear the chicken is in Bubba's mouth. He's got a chicken. Rob, it's 17 minutes. 17 minutes, so 49:59. 17 minutes. I have to make this thing shorter, huh? So from 49:01, 59:01, 17 minutes. So here we go. 17 minutes. Yes, focus, Rob. 17 minutes. That's the timer. It's set for that. Listen for that timer when it dings. Imagine in your head all the things that are taking place from this time while you're listening to Creighton Waters argue what's taking place. Yep, I'm getting accused of it. I see all of you. Lawyer math, and lawyer math. Yep, that's what happens. That's why, yep, lawyer math is hard. That's why I'm a lawyer. So we're going to continue listening to the argument, but 17 minutes is where we begin. So all the things that have to take place. Garden hose, or the hose is out. Paul is in the kennel. All of the parties are down by the kennel. A chicken is in the mouth. Here we go. And I'm going to start it right. Make sure this is open. Starting it now.
And what do we know? We know that the defendant was there just minutes earlier at the scene of the crime with the victims. 8:49:01. Paul's phone locks. He never sends that video to Rogan. You heard Rogan say that when he watched that video. You heard him say, that's the video I was supposed to receive. That is the video that my friend was supposed to send to me. And he never did. In fact, Rogan responds at 8:49:35, and he says, see if you can get a good picture of it. Mary Ann, his girlfriend, wants to send it to a girl. We know that's a vet. Tell him to sit and stay, and he shouldn't move around too much. Even though this is an active conversation with Paul, who you heard from multiple friends, was one to respond and use his cell phone. Paul never reads it. Paul never reads it. What happens at 8:49:31? Or 8:49:01 for Paul, 8:49:31. Maggie reads Lynn's response to the group thread about Mr. Randolph, and then her phone locks forever. It was never unlocked again until it's recovered the next day. Down here, 6:08 and 1:10. 8:49 for both of them. The defendant, after hearing multiple individuals of his family and friends and law partners get on the stand and listen to that video and say, that's him on that video, got on the stand for the first time and said, okay, I was there. He was forced into doing what he does all the time, and that's coming up with a new lie when he's confronted with evidence he can no longer deny.
Yep.
And the only reason he did that, is because all those witnesses at that witness stand said, yeah, that's him.
Okay.
Why would he lie about that, ladies and gentlemen?
Yes, Grumman, because we need to get through this.
Why would he even think to lie about that if he were an innocent man? Why would he even think about that? But he got on the stand and he told you a story, and we're going to talk more about that story in a minute. But his story was that he didn't want to go down there, and then he went down there, and he went down there really quick and got carried the chicken and went straight back, and he can't remember anything about what he talked about with Maggie. He can't remember the conversation at dinner. He's daggum sure about the fact that he went down there and went straight back. But even if you give him the benefit of the doubt, his story doesn't make sense. Yep. That kennel video is 50 seconds. It's over at 8:45:45. Even if you give him the benefit of the doubt that he could take care of the chicken and maybe the fastest dog and chicken chase ever, and put that chicken up and not say a word to Maggie and Paul and get on that golf cart and drive all the way back to the house, where does that put you? It puts you right at 8:49. At which point he claims he went inside and he managed to doze for a second. Then he's up at 9:02, perhaps the quickest nap ever. It doesn't make sense.
The shade.
It's a new story to fit facts he can no longer deny.
Yep.
From a person who, not a single person who was close to him knew who he really was. Not a single person close to him hadn't been lied to by this man. And I will submit to you that this one is the most blatant one yet. We'll talk more about that in a second. What happened at 8:49? Y'all been to the scene. That big room door is probably a bit tighter than this. But you saw the evidence from Kenny Kinsey and all the rest of them.
Great use of space. Great use of space. Stand in front of that door where the jury has seen so many of these demonstratives play out. This is really good. It's probably one of Creighton's better parts of the entire argument was when he's doing this narrative and the lies and highlighting those. This is the highlight of his argument. It's the best part of his argument. I started my timer because I have questions, but this is definitely the strongest part of his close. And standing in front of that doorway, puts a visual into the mind of the jury that they just saw that morning being on property. So this was a very good use of space.
Clearly, Paul was in the middle of that feed room. It's a kill zone. Nobody in there with him. He's in that room.
Kill zone.
No defensive wounds at all.
Excessive, but
his hands are down. And he takes that shot, buckshot to the chest. And any person who did that would probably think that took care of business because this buckshot, but for some reason he came this way and it went through. It was a 1,000,000 shot. But it didn't kill him. Alec thought of it. Alec, the lawyer, Alec, the prosecutor, Alec is thinking through that we'll see he's manufacturing an alibi, and he's also manufacturing the fact that there's 2 guns used. But we know, unlike the expert they call from Connecticut, where they can't even get ARs, he doesn't know about people riding around on property. He doesn't know about Paul and the 2 guns he likes to use. He doesn't know about this family and how common those guns are together.
I didn't really appreciate. I mean, that one was kind of that's a stretch. Like, he ain't one of y'all. He doesn't have their weapons up there up north. I know a lot of people in Connecticut that have firearms that might not have this particular firearm, but the shade to the north. Oh my word. And yeah, he's getting animated, so we're going to slow him down to 1.25 because he gets animated here. But man, hey, for those of you in the chat from Connecticut, I'm sorry, Creighton Waters isn't really a fan. Ugh. And for those of you who are away, yeah, Peter's doing his right now. I started mine at 7:15. I know he's doing 8:45. I'm redirecting everyone at the end of this to his. So, yeah.
Says, well, his only conclusion is, it would be practical for somebody just to fire out the clip. But this is him. This is Alec, the prosecutor, the lawyer, and he's thinking through this. He's thought through this. He's going to use 2 guns because it's going to confuse people that perhaps there were 2 shooters. But again, it doesn't make sense. 2 family weapons. But he thinks Paul's shot. And you heard the testimony that Paul appears in the feed room doorway. Is Alex putting down that shotgun to pick up the blackout and is startled by Paul? And that's why the angle's like that? And catches Paul like that? And goes up into the ceiling, as you've heard the testimony from Kinsey. And blows his brains out. And what happens with Maggie right here? We see activity on Maggie's phone. You heard about sandal prints. You heard from Kenny Kinsey about the mark.
Right there, another misstatement. He says, you heard about sandal prints. So he says, you heard about sandal prints, but from the Snapchat video, if I was Creighton Waters, I would have said other shoe prints. I wouldn't have said sandal prints because the Snapchat video, you heard that he was wearing house shoes. That was what Blanca said. The house shoes were in the Snapchat video, right? But Creighton says sandal prints. And then the shoes that he is found in when the responders show up on the property are the tennis shoes. So now you have 3 shoes. You have house shoes, sandals, and then the 3rd set of shoes. This was a statement that I don't think Creighton should have made, because now I've got 3 sets of shoes, which now implies that now I've got 3 changes from that first video until when he's at the scene. The sandals, were they Maggie's? Maggie was wearing the flip-flops, so Maggie was there right there at the moment. I'm reading the chat on this one. That's right, it did. The Maggies were showing hers moving. You're right. You're right. Sorry. 6 weeks of trial, guys. But bring that back. Why not bring that back? This is a good point. Why, if this is Maggie's sandals, here's the thing. If I'm the jury, I'm trying to remember 6 weeks of trial. And for those of you guys who are wondering, I've watched almost every single minute of this trial. In different times of day and night. I'm not going to go into it. I've watched almost every minute of this trial, and I can't remember all 6 weeks of this testimony. He's relying on the jury to remember that Maggie was wearing sandals in that moment. And he should have at the very least clarified it, because by doing that, he almost inferred that it might be a different set of feet. And if the jury doesn't remember that Maggie was wearing shoes in that moment, that could be a problem. Even if he makes I mean, it just, highlight that point.
Mark on her leg from the Polaris over there by the overhang next to the feed room. You've seen the diagrams and the crime scene photos of that all those cases are in that area between the doorway to the feed room and where Maggie was found.
Thank you, Janet.
You heard that Maggie had no defensive wounds. You also heard Paul and stippling from that first shot, a close range shot, with no indication that he detected a threat from the person who fired that weapon. And why? Because it was him. Same with Maggie, because Maggie sees what happens and she comes running over there, running to her baby. Probably the last thing on her mind, thinking that it was him who had done this. She's running to her baby.
Great argument. Great argument. But this is a great argument because that's what a mother's intuition is going to be. They hear a shotgun and they are going to run in that direction. In all due haste, they are going to run in that direction. So, yes, Maggie hears the shotgun and runs in that direction, which takes the time that Alex would have had to fire the second shotgun shot and switch to the AR, and takes that time from maybe 30 seconds and moves it down even closer. By making this argument, this is a solid argument. This is good emotional argument, great argument. But what it does from a factual standpoint is it takes the time that Alex, if he was handling both weapons, would have had to fire a second shot and switch weapons and bring that second weapon to bear on Maggie, who's running to him. Depending on where Maggie is, that timeline and that timing gets really, really tight. So this is one of those where the argument where he says Maggie comes running, I thought from a factual standpoint, this can add to reasonable doubt. From an emotional standpoint, this is going to speak to every juror in that jury box. Every juror that is a mother or a child and who has fond memories of their mother. Everyone is going to be thinking about that. But that takes the timeline from a factual standpoint and shrinks it. And he's got to bring a second weapon up to bear and fire it. I thought that was interesting. And then also people have raised the point that I think is also remarkably valid. Maggie running to the aid, the step counter. Do we have the steps? Do we have anything else there? It's a good argument. I think it can be not as productive as Creighton wants it to be in this moment. So this is hard. Like, this is hard. This is the hard part of these closing arguments.
Her baby, well, he's picked up the blackout and opens fire at close range, again with no defensive wounds. And she takes
to the chat, those who said that 13 minutes was the time from 9:02 when the phone starts moving, we have hit 13 minutes. So from when I started the timer, we are now 13 minutes. So from the time the Snapchat video sends, we are now at Alex Murdaugh walking up to the property and all the things he had to do between there. I'll get to the 17 minutes in a minute.
She takes those two shots that you heard Dr. Reber say were parallel, and it crumples her over. In those cases, you can see them move around. It takes that shot that goes through here. And she goes down flat. And then there's the shot in the back of the head. Malice? Is that malice, ladies and gentlemen? Is that malice to do that? Is that intentional harm to another with a bad intent, with an evil intent to do those things?
Is that a rhetorical question? Yes, it is, because everyone knows it is.
I submit to you. Clearly, it's malicious. clearly is malicious.
Nope, didn't forget the golf cart. I'll get there in a second.
She was running to her baby. Heard that shot, was running to her baby when she got mowed down by the only person that we have conclusive proof was at that scene just minutes before, and who lied about that very fact until he could no longer do it to you last week. Alex told you he went down there in the golf cart. We'll talk about this a little bit, but they had their expert come up here with the 5'2" people and all the rest of it. Be sitting in a golf cart. But he comes up in the golf cart. But what we don't see, as I said before, is any activity on his phone until 9:02. If the crime occurred around 8:49 to 8:53, down there at the feed room, State's Exhibit 516. It's just a diagram. Remember that Roger Dale Davis did about kennels and the hose there and how it wasn't put up the way he would put it up. If you're going to wash off real quick, what better place to do it? The water, the pictures of the water in States 199 and 190. It wouldn't take long to strip down and wash yourself off. Get in that cart and head back to the house. And then at 9:02, the defendant over there, who wouldn't even admit until forced to that he was even at the scene, all of a sudden, he is as busy as he has ever been. 9:02 to 9:06, 283 steps. 9:03, we see the system start up on the car, and that could mean that he's close by the car. Has he returned with Maggie's phone and placed it in that car? And then what do we see from 9:02 to 9:06? Not only is he 283 steps in that 4-minute period, but he is making calls like crazy. And I asked him, I said, what were you doing?
This is disingenuous. Making calls like crazy. It infers or implies that this is inconsistent with his normal behavior. They haven't produced any evidence to show what his normal behavior was. This was interesting to me. The making calls like crazy, but you had defense basically saying that he was a prolific phone user, annoyingly so. This part I thought was interesting. Oh, there's our 17-minute timer. So that said, let me do this real quick. I know that there are people that have been, I've been watching the chat. There are people that are saying, I could have taken 2 showers and done all these things by then. That's a possibility. Yes, 100%. That was 17 minutes from when we started the timer until now. The things that had to happen in that period of time. 2 shotgun shots are fired at Paul after, and Paul is in the kennel. This is when the chicken is being wrestled with. I don't know how long that took. You can guess whatever way you want to. I don't, just add that time. Chicken being wrestled with. Then Paul goes into the feed room. Maggie is then distracted enough that she is around the corner where they're not there. Alex then shoots Paul once, shoots Paul twice. Maggie comes running, shoots Maggie 5 times. Then after that moment, this is what Alex has to do. He has to essentially get the guns, wrap them up, move them into a position where they cannot be spotted. He has to be aware of all of the things, blood and spatter on his body and person. He has to take his clothes off, shield his clothes, remove his clothes, hide everything, then get to the hose that was previously running, turn it on himself, and wash himself to a degree that there is nothing that can be forensically detected on his person. That little part right there, I think people are kind of underestimating. But even if you're saying you can do that. So you do that, then you coil the hose, get the dogs back into their kennel, take the guns, hide them in a place where you're doing this. And this is all without emotion. Do that, then get your butt back up to the main entrance to the house, and then start scurrying around like you woke up from a nap while you're dealing with the phones and everything else in a 17-minute period. Some people are going to say that's a long time. Some people are going to say it's a short time. Here's my point. My point is that people are going to reach both conclusions. Can it be done? Yep, I believe it can be done. Is it reasonable to have doubts that it could be done in that time? And I'm going to phrase that question again, the exact way I just did. Is it reasonable for someone to doubt that all of those things could be done in that 13 or 17-minute time frame? If a juror was to form a doubt that said, I don't think they can do it in that time period, is that doubt reasonable or unreasonable? I personally believe that without a question, if someone was sitting in front of me and they said, I doubt someone could do it in that time, I would say that doubt is reasonable. I cannot say it's an unreasonable doubt. That is where I am with this case. I can take every single lie that Alex Murdaugh said, all of the lies. But if someone came to me having heard all of the same things and said, I have a doubt that that could be done in that period of time, I cannot, in good faith, look that person in the eye and say, your doubt is unreasonable. I think that's the best way I can think of how to phrase this, is for people in that jury box, if that timeline presents an issue and they have a reasonable doubt, I think that's the problem with the prosecution's case. People were making comments about the golf cart, and I said I would bring it up. How he could have used the golf cart. He could have. But the state didn't test it, so we don't know one way or the other. And if a question is outstanding, you actually are required under the law to side that question or take that question in favor of the defense. Which sucks. It's hard. Because that answer, had that question been answered, had SLED tested that golf cart, we would have a lot more answers. We would. I also want to remind you of what Alex Murdaugh looked like when he was interviewing. Was his hair soaking wet? Was he disheveled? The testimony about the phone calls, were they frantic or panicked calls? I'm not saying that he did or did not do this. What I'm saying is that if a juror sitting in that jury box said, I doubt that these things could have been done in that time frame, is that doubt reasonable or unreasonable? That's the question. That's the only question in this case. All of the lies, everything he said, view them against Alex Murdaugh as you wish. I don't believe a fucking word that comes out of his mouth. Not one. It's the timeline. If I'm speculating and in speculation zone and speculation land, could I speculate that he knew what was going to happen or he paid someone to do it? Yep. I can get there. That he most clearly he heard the shots? I can get there. That the timeline was later or earlier? I can get there too. I can get to all of these conclusions. You can reach all of these conclusions because if you start throwing out hypotheticals, you can get there. And that is also the problem with Creighton Waters' close. He throws out a ton of hypotheticals about things that could have happened and things that could have done. Well, the problem with throwing out hypotheticals and ways things could have happened is you can go down that road for far too long. That was my one big criticism of his close. Apart from the focus on the financials, that's everyone's gripe at this point. My big criticism of his closing argument was this is not the time to throw out ifs, maybes, possiblies. You need to dispel a lot of those, almost all of those. So that's the question that I have at the end of this closing argument. And I thought that Creighton Waters, with this walkthrough of the timeline, I don't think he sealed that deal. Now, I will give one major caveat, and it's something that's really important for us to consider. The caveat that you need to consider is that a lot of prosecutors They know they get the last word. The way these closing arguments work. Yep. And sorry, just seeing this real quick. Looking at defense tomorrow, blah, blah, blah. Sorry, didn't mean to do that. I think Rob Singing from a lawyer, not sure jurors are as critical, but I could be wrong. That right there, that is 100% fair. And I gave you guys that. That initial understanding from the very beginning. I told you I was trying to be very direct with you that I am viewing this more in terms of an attorney rather than a juror. I'm not a juror in that box. I'm just asking the question is, if one of those jurors came to you after hearing this evidence and said, I have a doubt on the timeline, could you look that juror in the face and say, your doubt on the timeline is unreasonable? Could you do it? That's the question. But here's what I was going with now, is the prosecution has two opportunities. They have their closing argument. Then the defense gets to poke holes. The defense brings their closing argument. But because the prosecution carries the ultimate burden of proving beyond a reasonable doubt that this transpired in this particular way, the prosecution gets the final word. This is a risky strategy, but most cases are like this, where the prosecution gives you a lot. Then they wait for the defense to give their argument. And when the defense gives their argument, they then bring back in their rebuttal close, they bring home all of the things. They lay down the hammer and they say, this is how it happened. This is what was done. Everything the defense said is BS because A, B, C, D, E. All of those things happen. It's a risk because if the defense doesn't open the door to you saying that, you leave it on the table and you don't get to make those arguments. We'll see. The rebuttal close is also the opportunity that most prosecutors take to really tiptoe that line of what they're allowed to argue and not allowed to argue, because that's their last shot. So we'll see. We'll see. I am remarkably curious. I thought this close left a lot in the way of information I would have liked them to bring. I thought that Mr. Waters did a great job, better than he did throughout the entire trial, in how he delivered his argument. I didn't like some of the remarks he made, but that's fair. I think anyone can reach that conclusion. And I didn't like the fact that he asked a lot of questions rather than give the answers. Now, maybe he's baiting the defense. The defense has baited the prosecution the entire trial. The defense has baited the prosecution into arguments that they knew they could rebut or they knew they could use to their advantage. So maybe the prosecution is doing that right here. And wouldn't that be poetic? The prosecution baits the defense into making an argument, and then a rebuttal close, the prosecutor comes back and lays the hammer. We shall see. But Creighton Waters took the opportunity to give what I am calculating about 3.5 to 4 hours of closing argument, and 1 to 1.5 hours of that was on the finances. If anything, I think that muddied the water more than anything else. I get confused there. So let's go to where this ends, and then we'll wrap up for the evening, because we have more stuff to watch tomorrow. Let's go to kind of the closing remarks of Mr. Waters as he brings his close to the conclusion. The forensics are going to be argued, and I want to wait until I hear the defense and the rebuttal close to argue the forensics on the shots. I want to hear both of them argue that before I give comments on how the forensics plays in closing argument, because this is very, very curious to me. Why am I? Oh, because they took a break. So we're going to the close. So we got to get to minute number 2. Watch the last 5 minutes. So 2:50. We'll go to 2:50 to 54. 2:50. Here we go. Watch the last 5 minutes, and then we'll go there.
And all those factors that he identified to you as to why he supposedly lied. He was lying to you, ladies and gentlemen, when he made those up.
Was.
He was lying to you when he made those up.
He was.
Just like he's lied to everyone close to him.
And that is fair.
And he's good at it. He's good at it. Is that up?
It was earlier tonight. I don't know the exact time, but I left. I was probably gone an hour and a half from my mom's, and I saw them about 45 minutes before that.
Mm-hmm.
I rode around with Paul.
So many words on the page, Creighton.
Motive.
Hang on. There we go again. Look at that thing. All the words.
Motive.
Yes, Kurt. Totally me with the chicken in the parlor.
The opportunity and ample evidence of guilty conduct and guilty conscience. All four factors are present. And Maggie and Paul deserve a voice. They need a voice because they can no longer speak. And this has been a tough job. But the system depends on people who take that oath as jurors and are willing to honor that oath and make that tough decision to vindicate these victims, to vindicate Maggie and Paul, who were cut down in the prime of their lives. This is a sealed exhibit. This is what he did. This is what he did right here. This defendant, on the other hand, has fooled everyone who thought they were close to him, everyone who thought they knew he was who he was. He's fooled them all. And he fooled Maggie and Paul too. And they paid for it with their lives. Don't let him fool you too. On behalf of the state of South Carolina, I ask you to return a verdict of guilty against the defendant, Richard Alexander Murdaugh, for the murder of his wife, Maggie, and his son, Paul, and for his possession of firearms during the commission of those malicious offenses. Thank y'all for your attention during this long trial.
Well, there we have it. So I kind of predicted at the very end that when he kind of sped through the damage done to the bodies early on, I predicted that he was saving that for the last salvo. And that's what he did. He saved those final remarks and the display of what I can only imagine is a very, very, very not friendly picture for the last words. And it was a very effective last statement. He fooled everybody. Don't let him fool you too. That said, I still want to see the defenses close. And I want to see the rebuttal close. And I can honestly see how everyone who has been watching this trial can reach different conclusions. This evidence can cut either way. It can. I'm just very fascinated by a lot of I like the dialogue. I like seeing it. So we're going to do this. Let's catch up on Super Chats, and then we'll get out of here, get you guys home, or get you guys back to your regularly scheduled programming, where then you can begin taking this up again tomorrow when we have the defense's closing argument. So, Jacqueline, thank you. At close today, the judge said they were heading into chambers. As everyone's leaving, you can see two gentlemen walk past council table right towards that door. Thoughts on who and why? I don't see that. Let me see if I'm going to just watch it on the side. It might just be council discussion on maybe the jury issue. I'm not sure. At least one of those people is the judge's law clerk or the research attorney who's there. So we'll find out tomorrow morning. Connie J, thank you. Watching before you were doing the YouTube thing, I absolutely do not believe you argue with the chat. I can see the passion for law as ingrained in your heart. Keep it real. Thank you, Connie. I very much appreciate that. I do have a very deep passion for law and making sure that these outcomes are just and proper. Lori Leanne, thank you. Please don't think you have to super chat for Rob to answer your question. He still answers chat questions. I do when I can. Hugs y'all, and thanks for being here. Thank you very much, Lori, for reminding, and thank you for that super chat. I do try to pull these up when the chat is as active as 3,000 to 4,000 people. It's very difficult for you to pull that. Also, that's a subtle reminder for me to basically say, if you guys are still watching, please hit the like button. It takes you 2 seconds. It does a lot for the channel, and it helps us keep moving forward and giving you guys this analysis. I get better with these things each time I do them, so I try. I think it's a lot of fun. I can talk with all you and see all your opinions. Creed M, would a reasonable appellate judge bang his head on the wall on the desk when they have to parse all the 404 and how the prosecution use it in their case? This is going to be a very interesting written appeal. Very interestingly written appeal. It will be appealed. It will be. Now, the merits of the appeal, I don't know. I think that there was a lot that was hung on that argument of the 404 and 403 and the financials. We will see how that plays out. It's going to be very interesting to read that. Crumfelt, thank you. For the record, I'm solid, not guilty. My point was, if financial motivated murder to this extreme with multiple victims and extreme cruelty of forcing mom to watch son's brain fly out isn't capital punishment case, then what is? It's pretty bad. And I think they recognized they had a stretch of a case. Everyone has. I think every attorney that's covered this, if they're doing so honestly, is recognizing that the facts here are harder to prove than what you might infer from different documentaries or things that you see on TV. So, but thank you, Crum. I very much appreciate you being here. Honestly, I love the input, some of the cartel stuff, all of it. I love it. Fantastic. Thank you, Crumfelt. Jennifer Johnson, thank you. LB had an axe, Lizzie Borden had an axe, gave her mother 40 whacks. When she saw what she had done, she gave her father 41. That's it. Yep, that's the one. Trials of the Century. That was one of our best episodes. Kay Bragg, thank you. Alex Murdaugh told us all the motive, but I think Creighton Waters missed it. Hate in his heart towards Paul about the boat case. Interesting. But I still don't understand why yeet over that. I know all yeets don't make sense, but still. Kay Bragg, I think a lot of people are there with you. Heather, thank you. Rob, did they need to add the motive to the case as they only have circumstantial evidence? When should you just ignore motive? Motive is important. However, you have to be careful when you go to try and prove motive. Because like I said before, if you try to go and prove the motive and you end up with a faulty argument, the jury can look at the rest of your argument and say, well, if the motive is that weak, shouldn't I look at this with additional grain of salt? It's curious. On the up and up, thank you. I would not have brought these charges. I wouldn't have brought them. I would have waited until financial crimes were charged and then just wait for the investigation to keep going and find additional information before I brought the charges. The waiving of speedy trial is known. That is known. Or the right to speedy trial and the possibility they might not waive speedy trial is known to the prosecution before they bring the charges. They are supposed to absolutely know the defendant has the right to not waive speedy trial, and that trial must be brought. So you need to have all of your S in a row before you bring that charge. Kanji Cosmos, I think murder shame trumps financial shame. So shame being the motive is a bit weak. That's interesting take. I think that's a possible. That's possible. YM, one possibility goes after Paul because AM is angry about the boat case. Toss the drugs. Maggie is a witness to the shooting, so she's dealt with as well. That is a possibility. But again, we're in the world of possibilities. Judy, you got this. Thank you. I was prescribed 100 milligrams of Oxy daily for severe rheumatoid arthritis. My body rebelled for a year when they lost favor. 1,000 milligrams a day, I call bullshit. That you can reach the conclusion on. Now, I don't think there was evidence in the record, and I think that was a part of the argument that was objectionable. Creighton Waters should not be and cannot be allowed to argue that 1,000 milligrams is not a livable thing if there's no evidence in the record to support that. That was stretching it, and I wonder if the defense is going to bring that up tomorrow. St. Elmo's Fire, Murdaugh are big Clintonites. We already read that one. Thank you. I don't think that there's going to be any pardons, period. Solo YOLO, as a male, can you guess at how you'd react driving up on a scene like that? No worries at all for the shooter still there. I don't know. I have thought about that more than I would like to admit, driving up on a family member that's been shot with this particular trial, trying to see what the jury might think. I don't know how I would act. I don't know. And one of the other things I want to add to that is you have to kind of, there's a certain amount of terror or fear that you have that the way that you act is going to be judged by others as indicating one thing or another when it might not be. So I don't know how I would act. And I would have a fear that my actions might be viewed as something that they're not. I have a big issue with some of that stuff. The real Sarah, when Alex Murdaugh was in the stand, he said the animals weren't alerting because no one else was down there. That's an admission. Yes, it is. Why do you think Creighton Waters didn't hammer that? Because he had them down there. He had them down there with the video. Christy M. Vasquez, do you know if the ammunition they found was unusual, or very common in the area? Would any person with a gun probably use the same ammo? That ammo was relatively standard. They had various boxes of that ammo. That's standard ammo for a 300 blackout and for the 12 gauge shotgun, birdshot, buckshot, all of it. It's not uncommon. Jean Louise, are the jurors told ahead of time they won't be allowed to take notes? I have ADHD and not being able to take notes would drive me insane. I think they were informed in this particular case. I think one of them might have asked early on. So yes. Sue Story, thank you. Maybe stupid, but perhaps all the calls and the 283 steps were the real killers calling to say deed was done and AM checking and creating an alibi. That's a possibility as well, Sue. Gingy Probs, your choice, closing before or after instruction. Oh no, you don't really get that choice. The instruction at the end by the judge, that's the judge. Judge gets the last word. So that's the judge gets to give the instruction at the end if they so choose. So you kind of deal with what the judge wants to do. Heather, thank you. Should the defense be objecting to the inaccuracies in Creighton Waters closing or bring it up in their own? How do you fix it? I am of the mind that I will usually not object and I will take the opportunity to highlight it in my own closing. That is my position. However, there have been cases where a attorney has gone too far in their closing and I've had to object because there's certain things that are said that you just can't unring the bell. So in this case, I want to see what the defense does tomorrow, and we'll see when Mr. Griffin takes up that mantle. Ryan Man YYC, can the defense stand up and say, here are the improper arguments the prosecution made to you? Yep, they can. In their closing, they're allowed to. And they will very likely do that. One of the most effective things that I've done it in previous closing arguments where opposing counsel made a closing where they were reading off of they read off of a printout of their entire closing argument. They read through it. The problem was when they were reading through it, they read through portions that were not actually the testimony that was provided at trial because they had written their closing early on in the case. So they read through things that were misstatements. And when I got up in the closing argument, I basically said, whether intentional or not, these things were misstatements of what was said. And by highlighting that in that fashion with my own words, rather than just an objection, it made it more impactful in my opinion. So it's a judgment call. Stephanie Wright, would we still be here if the grand jury wasn't lied to? I don't know, Stephanie. That's a good question. Caffeine, Cats, and Crime. I was convinced he was 100% guilty until this trial. Thank you for always making the info easy to follow. This one has been wild. Caffeine, Cats, and Crime. I will 100% agree. This trial has been interesting. The conflicting thoughts, opinions, and theories that came out of it have been wild to watch. And people are very, very well rooted in their opinions. It's going to be very curious to watch how this thing plays out. So, Nine Inch Nails Gal, thank you. Sing along to be Backstreet Boys time. I want it that way. I think I got that one. Rollerbot Creator, thank you. That was my question. How could he say the weapon was AM's without producing the weapon? I don't know. I wonder if the jury's going to ask that question or not. It might just be a me question. Who knows? Megan Kokenderfer, wondering if the weapons wondering why the weapons charge against Alex. The use of a weapon is an enhancement. That's an enhancement on the charge. It can be a separate charge as well. That's why that charge was added on or tacked on, because it's an additional charge that they can prove if they get the conviction that he actually did the thing. Gingy Probs, anyone interested in the future of tool mark analysis, go read the book about my childhood dentist, Michael West, the Cadaver King and Country Dentist. Very curious. Thank you, Gingy Probs. Everyone go check that out. Michael West, the Cadaver King and Country Dentist. Chris and M96. Manager saw, repeat, Alex Murdaugh can appeal ineffective counsel. Oh, can appeal ineffective counsel because they let him testify. I don't think so, because it was his choice and judge informed him up on the 5th. Can he? No. His decision to basically testify is his decision alone. And the judge reading him through that dialogue, that colloquy, is to basically do away with any arguments that he didn't do so knowingly. So no, that him choosing to testify, that's not an appealable issue in this case. Beverly, Alex Murdaugh wore hunting clothes to prevent blood on him. After murders, he changed the clothes, took the bloody outfit and guns off site to Alameda and hid in tree line until he could go back to dispose of them. Beverly, that's a possibility. That is a possibility. I'm not going to say that anything in this case is beyond the realm of possibility. What I will say, though, is that with a trial that is a murder trial where you're trying to deprive someone of their life and liberty, and the state is doing that, the state must prove to you what was done beyond a reasonable doubt. Even if it is with circumstantial evidence, that proof has to be beyond a reasonable doubt. Ryan Man YYC, why lie an innocent man might fear SLED's incompetence and worry they will use the first piece of inculpatory evidence as a compass. Ryan Man, you are more accurate than I can actually even elaborate. I will tell friends repeatedly when they argue with me about circumstantial cases and case law and how these trials occur. And one of the things that I oftentimes say is that every single human being in their life is 2 bad facts and a lie away from a conviction. The interactions that you have in your daily life are pretty complicated. All it takes is a couple of bad facts and one lie that you believe is innocent in that moment, and you find yourself on the wrong side of a prosecution. It is not beyond the realm of possibility. Talk to anyone who's been charged, talk to anyone who's done time, talk to anyone who's had to face the power of the state, and whether it's right or wrong. 2 bad facts and a lie. Wrong place, wrong time, bad excuse. And you're there. I'm not arguing for Alex Murdaugh. I'm arguing for the next person. And the investigation that puts someone else behind bars needs to be really a hell of a lot better than this one was. So that's my issue, is with the investigation of the state. XCDA, thank you. I do love seeing the energy and excitement of the closing arguments. True. Thank you for pointing out the issues that I missed while being entertained with the best part of litigation. XCDA, that is very, very valid. And for me, it's watching it with a different set of eyes. But yeah, this is kind of where you get to that peak in the drama. Dana Parfait, thank you. If there is anyone on that jury with an analytical brain, they're going to take a lot of what Creighton says and give the specific charge significant doubt. He hands them the doubt. He did that twice or 3 times in that argument. You are right, Dana. Thank you very much for the super chat. That's very, very kind of you. And also, I think your analysis is pretty right on. Krista Peterson. Hi, Rob. 1, do lawyers get in trouble if a case is overturned on appeal due to ineffective assistance? No. 2, what would your appeal strategy be for AM? Hammer the decision to let the finances in the first place. That is right there. The possibility that that makes this a trial within a trial. And what I think that you saw is that when the judge made the decision to let that in, I don't know that even the judge saw how much of it they were seeking to introduce. So that would be my appeal advice. Liquid Sunshine, thank you. Maggie left her phone in the golf cart when dealing with the dogs. Possible. Ran to Paul and died. Also possible. Alex took the cart back to the house and realized he had her phone, had to get rid of it. All of those are possible. You know what would be great? What would be great, Liquid Sunshine, is if SLED had tested the golf cart or seen it or done any review of it. Then we would have answers to that question. It's a possibility, but again, in the criminal case, we cannot convict. The law does not allow you to convict on hypotheticals of things that might have happened. You actually have to prove beyond a reasonable doubt that that is what happened. Kanji Cosmos, thank you. I would have loved if the state tested for evidence of on the hose. That would have been very curious. Very good point. Grab that hose, test and see if you see anything, or go buy the hose apron, like right there. I haven't seen that comment made. That's damn good. That would have told us a lot. People have asked me what it would take to get me, like in a circumstantial case like this, to possible guilt. That's a big one. If they found blood evidence there. Yeah, that's good. I like that. Solo YOLO. Thank you. I just learned that Alex Murdaugh's brother sued him for $90,000 in 2022. Alex confessed and tried to pay him before the victims. Tinsley had to get an emergency stay. That will happen from time to time. I will say that those clawback actions from Tinsley and others will occur, and they will stop that transaction from taking place. Kurt came in with a super chat. I saw this when it came in. Rob is 5'2". Rob did it. Rob is not 5'2". Rob is 6 feet tall. I am 6 feet right on the nose. And no, I was nowhere near the scene at the time. I don't think I was. But if I did, it would be with the candlestick in the parlor next to the rooster that was slain. So it was in retribution of the rooster. No, Kurt, I wasn't there. But thank you for being here. I have watched you in the chat. You've done great today. I love it. Burberries, thank you. Just look at how split and heated the chat responses are. I can see the deliberation room getting tense and possible hung jury at the end. That's a fair assessment. The commentary, the opinions around this trial have been very, very contentious. I have appreciated that, at least in this chat, I have seen that most people, almost everyone, all of you who are still watching and who have been watching, have been respectful in your remarks. And I thank you for doing that. Like I said, a friend of mine, Richard Hogues, reasonable minds can differ. I would very much like for reasonable discussion and discourse to reintroduce itself to society right now, because I feel like a lot of that is lost. Sid, thank you. Could the prosecution have simply said no one knows why he did any of this? Or is that not an option for a successful prosecution? Sid, you're right. They can say no one knows why he did any of it. The reason why they want to say why is because a lot of people have as a natural thought in their head, well, why? That's what they have. And some people won't get to guilt without understanding the why. That's why they try to do it. For the kids, thanks again, Rob, for doing this and spending your precious free time to give us the analysis. I appreciate the questions you pose to make us think. Thank you for the kids. It really is. It's about the questioning. LJ Peach, thank you. DA has an axe to grind for the financials, but didn't prove the murders. That's a fair assessment, I think. T-Mac, will you do a stream talking about all the charges against Alex Murdaugh, not just the murders, financial, drug trafficking, etc.? We'll see. Let me get to the end of this one, and then it might be interesting just to recap some of the finances separately to see what it is, but I don't want to let that kind of influence how I'm viewing this. I am trying to limit myself as much as possible to knowledge that I'm gaining from this trial, because I don't think it's fair for me to bring in outside stuff. For example, the Netflix documentary, HBO stuff, I know there's information there, but that's not been presented in court. And in court is what the jury is relying on. And honestly, my analysis doesn't really give you guys any benefit because I'm not a true crime guy. I give you kind of the law, and that's the part where I have fun and where I have something to add. So thank you, T-Mac. Marianne, thank you. If the appeal is successful, can he be tried again? It depends on how. Generally speaking, in this particular condition, the appeal, if successful, would say that the trial would need to be retried. They would need to bring the trial again. Then you would have different issues that would be raised, such as moving a venue, the evidence that gets introduced, et cetera, et cetera. So it is likely that an appeal would result in a remand with instructions on how to correct the issue that was the error in the first place. Bella Brat for you. Cheers, Wood Daddy Stacks. I so love your perspectives, from the knife experiment with Depp V. Heard to your phone time experiment with this case. Thank you for all you do. Bella Brat, thank you very much. Appreciated. I really do like doing this. I like doing this I like it a lot more than I thought I was going to. It's a lot of fun being able to talk with all of you guys. And even if it involves me throwing my phone around that room and seeing what turns it on and activates it, it's a lot of fun because I get to learn. And I get to share that learning experience with all of you guys. It's great. Sphinx Catware AM had someone pick the guns up and clothing while he visited his mom and dad. That's a possibility. The other possibility is that he knew that what was going to happen was going to happen. Heard the shots, knew what it meant when he heard the shots, and left the scene. And the person that either he knew was coming, hired to come, they did all those things and he came back, which explains the 17 seconds. He already knew they were dead. But that is not that conclusion right there. That is not guilty for murder. That's what that is. And that is the issue with the prosecution. Trisha Lynn, thank you very much. Seeing your YouTube rise keeps me working to grow mine. Trisha Lynn, I hope that you enjoy it. Do it for fun. It is a fun thing to do, and I'm very glad to see that you're making content. I think that more voices out there, the better, and I love seeing people create, and people love doing it. It's fun. It's a lot. It's a lot of work. It's a lot of stress, but it's a great time. So thank you. Moon, why Jim closing and not Dick? Dick seems more affable with those in court. The affable with those in court might be a perspective that we're gleaning from outside perspective looking in. I don't know how it's reading in front of the jury. I don't know. This is a judgment call that's made by the defense, and we're going to just have to see how it plays out. Bella Brat for you. Yes. Arguing for the next person. Arguing for the next person. Yes, exactly. Yeah. These points are not being made for Alex Murdaugh. They're being made for the criminal justice system in general. You cannot make rules for all of us based on conduct of the worst of us. The importance of that is so significant and so often understated or not stated at all. Alex Murdaugh's not the person I'm afraid of, or the case I'm afraid of. It's the next person, the next tool mark analysis that's bad or faulty. It's the Lindy Chamberlains of the world. It's the Guy Palmerans of the world. It's the people that were wrongfully convicted of the world that I'm concerned for. Not this. If this cannot serve as an example of how to do a prosecution, in my opinion. Susie Q, what trial could possibly follow this one? I have no clue. I know that Koberger is interesting right now. You've got some information coming back. Alec Baldwin is there. FTX, Sam Bankman-Fried's going to trial in October. I have my eyes on that one for damn sure. That's going to be interesting. So we'll see. Good Grant. Sled cut Alex Murdaugh a lot of slack at the beginning by not investigating everything thoroughly, and it's paying off now. And that's a problem for Sled. If Alex Murdaugh is found not guilty, rather, let me put it this way. If the jury comes back and determines that reasonable doubt was not proven away, then that comes back on Sled. And that is a message to everyone in that community that they need to fix the actions of those investigators to make sure that this type of thing never happens again. That is the corrective action that needs to take place. And I think that a lot's been done already. I just think that it's a big deal. Susan Ferry, thank you. Alex Murdaugh did everything good to protect his son and then kill him when his wife cleaned everything up in 17 minutes. Question makes no sense. Susan, I don't know that I disagree. I don't know that I agree. I think that there are jurors that can reach that conclusion and not be unreasonable in reaching that conclusion. Nicole Christine, will you stream tomorrow to talk about the defense closing or save for Friday Night Frenzy? Thank you for all the time you put in the channel. I have found that this content, basically trying to do a recap of an entire closing argument, is too comprehensive to try and condense into a Friday Night Frenzy with me keeping that thing to under 6 hours. So I will very likely be streaming tomorrow and doing a recap of the closing argument tomorrow. So we will see. I'm going to try to do that, and we'll just take it from there. Janet, thank you very much. Everyone seems to be saying he's hiding something. What if someone told him to leave, killed him, and threatened the rest of the family? That is a possibility that I have not dismissed out of hand. I think that is a possibility that stands in line with a lot of the other possibilities that have been raised. So I don't think that y'all are entirely off the mark in this. I think that there's a lot going on. Yeah. Shell, FNF gets so long with, yeah, that's the point. I'm trying to keep FNF a little bit shorter without the Murdaugh stuff. So yeah, I'm with you on some of this stuff. So that said, here we are. It's 10 o'clock at night because, of course, I can't keep these streams short. 2 hours and 40 minutes later. I hope you guys got something out of this. We have the defense closing argument to watch tomorrow. This is going to be very, very curious as well. I do want to say that I want to say thank you to Sandra Ramirez for gifted memberships, Joshua gifted memberships, Vintage Willow gifted memberships, Chuck gifted memberships, Joshua some more memberships, Neurodivergent Counselor gifted memberships. All of you guys, someday StreamYard will fix the ability for me to pull those up. I wish I could, because honestly, I love that you guys do that. That is so much fun. Just adding people to the community and making them feel welcome and great. So, but Friday Night Frenzy, FNF is Friday Night Frenzy. That's my Friday show recapping the week in the law. And hopefully we'll have some additional content this week that's not just Murdaugh. We'll probably touch Murdaugh, but maybe not all the way. Nanner, been here since the start. Never said this before. You're a good man, Rob. Thank you. Nanner, thank you very much for that. Those comments mean a lot more than you guys realize. It's a lot to be on a screen talking to you guys about something that's kind of controversial. And I pride myself in the ability to kind of do that in a fashion that is respectful, but also not hiding away from the things that are controversial. So thank you guys for being here. I'm going to bid you adieu for the evening. I hope you have a wonderful night. And I very much hope that you guys are doing well for the rest of the week. Enjoy your Thursday. Have the best Thursday and a great end of the week. Hopefully I'll catch you back tomorrow. If not, then I'll see you on Friday. But in either event, thank you for tuning in, and I'll see you next time.